Please be seated, please.
Number. Okay. Yeah.
So long to do all this. That's true.
I don't mind.
That might be the way. Well, I'm already kind of ahead of everybody anyway.
Yeah. I think there is.
All right, good morning, everyone. Go ahead. Okay, let's do a calendar call. Positions 1 and 2, Michael Kenny. I know Drake filed a conflict for this meeting, for this final plea, but who has this with the state again?
Judge Shawn Iqbal from the state.
Okay.
And just to let you know, we're in talks, but this is the case that we talked about last time we were in court to be after Nasia Reed's case. This is Michael Kenny's.
Well, I know it's the Michael Kenny case, but what did we talk about with Reed again?
With Michael Kenny to especially set it, to
Yeah.
put it after Nasia Reed's. Remember that Nasia Reed's is for the 24th?
I'm going brain dead here. What's the issue again?
No issue, no issue. I'll talk with these.
Okay. But I mean, are we ready for this case or?
For a final plea?
No, I mean to go to trial with it.
Yes.
Oh, okay. Now, are they gonna be tried together or?
No, Judge, I
So we
believe,
would go with the 18 then, right?
correct, and then that will resolve the first number.
That's right. I do remember that part.
Yeah.
Okay.
Your Honor, position number 1 is mine. It was my understanding that both of these cases, it's the same defendant. Both of these cases were gonna be reset to the November final plea calendar.
That's what it was my understanding too last time we were in court. That's what I was trying to get at, Your Honor.
Kathy? What's the deal with that? Where's Reeves on here?
It's not, Judge, it's not on here. It was on last time, the last final plea, and then I asked the special set date, because my witnesses are out of state. And that's when the court gave me the 24th of October.
Yeah. Well, why does this need to take place after Reeves?
It could happen before. Our only concern was the October calendar.
No, wait a minute, I'm not following this. I mean, this is, a second. I thought this was specially set for the 14th,
14th of,
September.
Yeah, I did set up special set.
is especially set for the 14th?
I did set out a special set I did not a notice of special set for this case.
Ms. Catherine, when did you send that out?
They set it out, they told you on.
Right, I believe this happened, we had a conversation last week, I believe.
I set it out.
Judge, I can get with Ms. Kathy and we can figure it out.
Well, I mean, the only worry that I have is that, I just want to make sure we end up having a trial on the 14th. I mean, the 18th, yes, the 14th is the calendar. All right, so you'll talk to them?
Yes. Yeah, I'll talk with Ms.
Okay. What? I mean, does Drake know this? I mean, cause I thought that we had nailed this date down. I
She
mean,
said, they Friday.
yeah, but I mean, I was gonna delve into that. I don't know whether the cases that she's saying are conflict are older than this one. Are they?
Oh, her case, she's
I mean, check and see. I mean, what one are you looking to go first then on? I thought Kenny was the first one we were looking at.
so that's the one that he's been.
Yeah. There's no hope in it anymore. I mean, we gotta, there's no hope in that. We'll have an empty courtroom again this month, if we hope. Position 3, Reed.
Morning, Judge.
Morning.
Judge, I have the next week's trial. State maybe if you offer.
Why don't you come up to the microphone?
Morning, Judge.
Morning.
Scott Smith on behalf of Trinice Reed, position 3, I believe, on the calendar.
Yeah.
It does not show up on your trial calendar because I have to be filed when I'm golf trip this week.
That takes priority over everything. You know, no, I'm kidding.
I mean, 23 years of practice, I realize working, 52 weeks straight is not a good idea. I'm taking vacation this week, flying out to abandoned dunes and play golf.
Remedy is. When was that filed?
It was filed about 3-4 months ago, long before the published.
Okay. All right. Looks like that one's reset.
Yes, Judge, I should let everybody know, in this case, she's competent to stand trial for sure. She does have a history of mental health issues.
Yeah.
I'm exploring that. The family has come up with funds for a private forensic psychologist. She's backed up. So I'm gonna put that on the court's radar. I know she's been in custody for some time. It's me that is asking for the continuance. Should it come up anytime soon? I just think to do my due diligence, probably proper to get her fully evaluated to see.
I mean, I know you mentioned that in the Jackson demo.
Yep. And I did get the court's order. Thank you for that as well written. Even though I lost.
Well, next. So are there any other outstanding motions on this?
Not that I know of, Judge. Pretty straightforward case. And it's not that many witnesses. The vast majority of the witnesses are law enforcement witnesses.
So what do you want to do about getting this on a trial count? I know you say, so the family's hired a forensic psychologist and you're saying she's backed up.
Yeah, Dr. Christine Gleiser out of Marietta. And I spoke to her over the weekend. And she's 7 months pregnant too. She doesn't even have Ms. Reed on her calendar to see her prior to having the child. So I just need to logistically figure everything out. And there's medical records out of Colorado and Florida that we're working to retrieve. I don't know that this is a not guilty by reason of insanity defense. I think just to do my due diligence to go ahead and have the evaluation done.
But I mean, I guess so we're talking about his proposed forensic psychologist who has a heavy calendar and is also having a baby.
Yeah.
I mean, when do you see us trying this case?
January, February.
Let me hear from the state on it.
The state's ready, Your Honor. I believe the last outstanding motion you filed, the order on September 8th. So, state's ready.
We're sitting here in September. I mean, you don't have any other options as far as a psychologist or?
I'll check with her to find out if somebody else in her office can handle it. She works for, she works in a large firm, so let me see if there's somebody else in her firm that's available.
See if there's someone else in the firm. Obviously, I'm resetting it. You mentioned the mental health exam and the Jackson Deno, and you've had this lead book, so we're obviously not going to trial on this this month, but I'm not sure I want to wait till January or February either.
I get it. I mean, it is what it is. If I feel as though, I'm kind of torn because I don't know that this is a mental health offense. I think she's got a very robust case. The state has offered us 20 years to serve on a reduced charge. So I'm in a position where, if it does come up, I probably will just try it without having her interview. But she is competent to stand trial. She's been deemed competent.
All right, anything else from the state?
No, Your Honor.
Okay, all right, you're excused. You just,
Your Honor, that concludes my business. The excuse.
you're excused. All right, position 4, Kwasi Little.
The co-defendant, I believe, is Shin Patterson.
Yes, that's right.
I received a call from, Pretrial Services, Ms. Ingram, she's on her way here. Her car overheated, she was stuck on the side of the road, so pretrial officer told her to call somebody to have them to her up and bring her over here. And, her attorney, check her, sent an email.
I got it.
To the office.
Amazing.
Yes, Your Honor. Doing well, thank you. How are you?
Doing well.
So this is on final plea.
Well, it's on final plea, but Little and Ingram are co-defendants, right?
That is correct, Your Honor, and, speaking with Ms. Robinson this morning, we have motions in this case, that we would like the court to hear prior to trial. There's an outstanding, it's reverse Jackson Deno, but, the state filed a motion for the court to rule on the voluntariness of the both statements. In addition, we have, engaged 2 gang experts. One or both may be testifying at trial. As Your Honor knows, we added gang charges a couple of months ago. And so.
And they both have reverse Jackson Denos?
They do. And as to the gang experts, I believe, once our summaries are finished to what they're testified to, the defense may want a downward. Can't speak on behalf. Unless the defense consents that the statements are voluntary and that our witnesses are gang experts.
Why would the defense want the downward? You have an expert?
We do. We have the initial expert that we filed was on the initial witness list, Charlie Lida. We filed their
Potentially.
potential expert, filed his CV with that. And most recently, we engaged another expert, Captain Taylor, with the Fulton County Sheriff's Office. He is reviewing everything and will be giving a summary to us for us to serve on the defense. He's a gang expert, filed a supplemental witness list, as well as a 418 motion on Friday.
All right, Ms. Jones.
Thank you, Your Honor. Yes, the state did file a 418 motion late Friday afternoon. I haven't had a chance to review it. I'm sure we will want to respond to that. And I would just make the note for the record to date. on the eve of trial, I've still not received any evidence to tie my client to a gang, despite the fact that this was re-indicted, I think, back in May. And I'm still waiting for that, and I've asked several times. But otherwise, we are ready to proceed.
For the record, Your Honor, this is not the trial. We haven't even had hearings in this case. There's a procedure for every case, and we should have hearings prior to the trial.
And again, Your Honor, it's hard for me to proceed on 418 when I haven't received anything of the evidence that the state is going to use against me.
Space.
We don't even have a hearing date, Your Honor. Once we get a hearing date, they
But
will
what
definitely.
about the discovery?
The discovery, they have the discovery. As to the reports for the gang experts, when they're completed, they'll get it, but it will definitely be 10 days prior to the hearing. That's
Okay.
statutory.
All right.
We have 10 days prior to the hearing.
We can do a hearing this week.
Well, the reality is, I know that your client, I know this is not a concern of your client per se, Ms. Jones. Mr. Tucker filed a very compelling conflict letter, email. So they're co-defendants. My plan is to reset. We've got motions to do.
And I do have bad dates for.
I know you've got a speedy filed, so. Pardon me?
I believe Ms. Jones, correct me if I'm wrong, that speedy was withdrawn at a prior court date.
No, we just filed a demand for speedy, putting the state on
Yeah.
notice that the clock is ticking.
Right, not a speedy.
Well, I know, but I tend to give that a little more attention when they do it. I mean, I know everybody
Well, yes, and the state would like,
wants to. Go ahead.
the state would like to, do the hearings and try this case. And I do have bad dates for Detective Sluts who will testify in the hearing. I have bad dates for the co-counsels that are in this case. And so we're ready to set both hearings and trial dates today. Well, it's given Mr. Tucker's email, but other than that,
Okay.
I think putting something on the calendar better than
Do we have dates for any motions?
half a day. I presume if Your Honor would like to watch the statements in
I would.
chambers, and then we have two experts. I don't know if they're doing that work.
I mean, it would be helpful, I mean, obviously copy counsel line to, if there's particular areas on those, videos that you think I should zoom in on, so I don't overlook that. So
Yes, Your Honor.
why don't you get with them on? Well, I don't know if we're moving forward with it. I mean, we've got Mr. Tucker's conflict. I mean, he can't go to trial, but I mean, I'm all for, well, he can't be around for the reverse Jackson down
Or the Daubert.
or the Daubert. All right, we'll come up with a date and give it to him, but I can't go forward with Mr. Tucker, right now.
This is the first week of October. Any day that week works except for the 6th, which is Friday, if possible. So the first through the, the second through the 5th. if possible.
So let's set the motions and then set obviously the trial subsequent to those motion dates. Can you do that? Will you get with them? Half a day for motions, okay.
Yeah.
All right. All right, what about position 6, Pitts?
I
May I be excused, Your Honor, or are we gonna wait for the defendant?
No, I mean, I think we've got our announcements there, so.
I am
Yes.
not.
You're excused. Position 6, Pitts.
Good morning, Your Honor. Derek Wright for Short Pitts.
Right.
All right, Mr. Pitts, do you have any announcements on this?
Well, I don't think there's ever.
I'm sorry, Mr. Wright.
Yeah, I don't think there's ever been an offer conveyed, but I'm not necessarily surprised, but we would, I guess, stand to be ready, subject to my conflicts. I have a few special sets. The last 2 weeks of this month, special set, and the last 2 weeks of next month.
What about the state?
Good morning, Judge. Vincent Fawcett for the state. So I wasn't aware that there had been discussions regarding the negotiation. I will get this right and all of that. And we'll be ready when this case is reached.
So did you file a conflict, Mr.?
I've been adding it on every conflict letter of my special sets, just sort of give the courts the heads up. I know Judge Krause wants me next week for a 10 SC case that's being retried. The week after is Henry County, which is Judge Mara. And then I have 2 murders the last 2 weeks of October with Judge Malone and Judge Jules Scott.
What, are they older cases in this?
I think you might be older than the Clayton cases in October. I definitely know not the 10 SC with Judge Krause next week. And then I think it might be older than for the 25th, maybe older than Judge Maris. I think that one is 2020. I'd have to refer to my conflict. But I'm clear the first 2 weeks of October. I'm not sure what all court has.
I mean, the thing is, we were in here last month, and we talked in terms of the June trial calendar for this case. Month ago to the day, well, almost to the day.
And I apologize, my special sets have bumped me around pretty chaotically. But I keep thinking I'm almost back, I'm on almost smooth sailing, but I'm at the course pleasure.
So you have 2 potential trials next week?
Yes. One is Raul Lynch and Judge Krause. I'm hoping we'll get that resolved, but I can only say right now, it's probably a 50-50.
What about the Amero case?
The Amero case is definitely gonna be a trial, but I do think this is probably older, because what is this, like? 18? Yeah, I think this would trump the Henry County indictment. I'm sure that's a 20 or 21. Whenever I sent my last conflict, they're all listed, so you can see the indictment numbers and.
Is everything, do we have any outstanding motions on this? Looked like we were ready to go to trial last month.
All right, well, let's leave it on the calendar then.
For the 25th,
18th?
well, the 18th is Judge Kraus. That one is over. That's a 10 SC.
Yeah, but you said there's a chance that could settle.
Yeah, I'll, if I can just, I guess,
Talk to
advise
Kathy.
the court how that plays out, that if it resolves, then I'll be available on the 18th. All right. I'm just guessing it's about a 50-50.
All right, we'll leave it on for now. We'll stay in contact with Kathy.
Understood. All right. Judge, may I be excused?
Your excuse.
Okay, thank you, Judge.
Which one do we get 10 special?
Yeah.
All right, position 7, what? I know. You know, but they disappear. Poof. You're feeling my stress down there, you know, where it's coming down on you. All right, position 7, Corey Marshall.
Turn on the mic, because I believe Mr. Marsh is present by Zoom. Your Honor, I just wanted to, I guess, get some clarity on Mr. Marshall, because I know this was the case that was talked about being sent to the consolidated trial calendar. I did get notice last week that it was set for a motions hearing on the 25th from one of the Orca judges. So I'll say, I mean, these motions in limine that are set down are pretty standard. I don't envision they're going to take a lot of time. I think we can put stuff on the record today. If need be, if Your Honor would like to call it next week, I guess wanted some clarity, and we'll be ready for trial next week, I believe, subject to whatever the state's announcement is. But I guess wanted some clarity on whether this is going to be on the 18th or whether it was still going to consolidated calendar.
When is the consolidated?
They're ready for this week.
Surprised this even made it onto the consolidated calendar. People have been in jail a lot longer. But, so, Ms. Marsh,
Yes, Judge, good morning.
I can't hear you.
Uh-oh. Can you hear me now, Judge?
We can't hear you, Ms. Marsh.
Judge, I could come down to the courtroom if the audio is having
We still
trouble.
can't hear you.
Can you hear me now?
She's coming to the courtroom. All right, we'll come back to Marshall then. All right, the group, position 8.
Morning, Judge. I'm here on behalf of this group, and I think that we got some Marshall case as well. We've got a sign for that case. Wait till she gets here. Address that one.
We'll wait till she comes back. I see that they're listed on a, Bruce listed for the calendar call, but not the trial. He is? No, I have him on that, but I'm saying as far as a notice. All right, we'll come back to that. Position 9, Millen.
Your Honor, these are, position 11 and 18 are, defendant Millen and defendant Gibson are both my cases. There is also a defendant, defendant Royce Bell is on this case, and if memory serves me correctly, Mr. Bell, because he has multiple cases, the court had reset his and further noticed his cases so that to provide Mr. Clark and I opportunity to work for those cases. Just to let you know, for defendant Millen's case, it's my understanding that Ms. Bumpus is representing that defendant. An offer and discovery have been served for that case. And then for position 18, Mr. Deshae Gibson, it's my understanding that attorney Andrea Roberts is representing that defendant. We have been in talks. The state has provided an offer. There has been a counter offer that's been made, and discovery has been served. The state is ready on both of these cases. However, we do intend to try, if the case were to go to trial, we would want to have Royce Bell included as well. So just to let you know, like, since it appears those attorneys aren't here, Ms. Bumpus, Ms. Roberts.
Ms. Bumpus said she's on her way, running late, and Ms. Roberts, she said she was hoping it would be approved today. So she said she was on her way. She was also running late. She asked to hold her.
And what about Royce Bell? Where is he?
Bell, he is actually on the calendar.
But they're all co-defendants.
He is on the calendar. He's got 1, 2, 3, 4 cases. He's on for October 2nd.
Yeah, but there's no point in having these. I mean, if somebody's gonna take a plea, that's one thing, but if Bell's not here and the other two are, they.
Well, Your Honor, I think that Ms. Robinson may have put these cases on because I know that for defendant Gibson,
Yeah.
we intend to possibly be able to do a plea on that one.
Well, that's what it sounds like.
Right, and for defendant Millen, the offer I've made is pretty much the same. So you know, if
Maybe there'll be
Attorney
some,
Roberts was here,
she's on her way.
yeah. So I know that there was an
Okay.
announcement last time that these cases would be able to resolve, so I think that that is why
Okay.
Ms. Robinson put these cases on.
All right, fair enough.
Yeah.
All right, let's go to Parks. Position, it's a mine, it's position 10.
I am present on that, Your Honor. I would like an opportunity to pre-file that.
Okay. Position 11, Young.
And Your Honor, I'd like to have a chance to pre-try that as well.
Okay. Let's start. When I see somebody raising their hand. Oh, Ms. Ingram. Yes, yeah, no, I appreciate you coming. They said you were having car trouble and you have a very good record of attending, so I did not dispute that. We have reset your case. I'm sure you've heard about your attorney. Okay, due to that. So we're gonna reset it. We've got some motions that need to be heard. We're gonna schedule those motion dates and then we will reschedule trial. Other than that, you're excused. Okay. All right. Position 12, Harvey.
I am present on that, Your Honor. I have been provided the initial police reports. However, I am still missing body cam for that. But I can talk to the state legal contract as well.
Okay. Is this yours, Ms. Clark? Probably, I guess.
I thought, well, yes, Your Honor.
Okay. Duval? So here, Duval,
Yeah.
do you have any sort of announcement or?
I do, I believe this is final, and, we discussed this, we're gonna reject the state office. I have not been to communication from the court yet, so I'm not sure what to try to make. Perhaps I should see this act,
Well, pardon me?
and I just joined this case of
Wait, I see him on the trial calendar for. I don't know how we can notice that. Hold on. Let's wait till your client comes out. We'll circle back around. Terry Harden.
I am
He has
present
two
on.
positions.
Yeah, I am present on both of those cases, Your Honor. State requested them to offer for me, so I'd like to pre-file this.
Okay. Already talked about Gibson. Murphy? Lee Murphy. Oh, apologize, Your Honor.
We reset this from the last final, but Your Honor, because new unindicted cases, we wanted to see what happened with those. One of those was found over, he's sitting on the non-status, the other was dismissed for the preliminary hearing. What I can let the board know is I haven't received an offer from the state. I've received some preliminary discovery, but as noted in the reports, the photographs taken, injuries as well as statements on body cam that I have not received yet. So for those reasons, I don't think we're going to be in a position to resolve this case today. I'm asking this.
Mr. Clark?
Judge, it's my case.
Oh, sorry.
Shall I call this thing, Judge? I have an offer, but I want to do a global for all the 3 cases. So if we could just do a one-time reset so I can get those indicted so that we can resolve all the cases.
I thought that he said that one's not gonna be indicted.
No, it was dismissed on preliminary hearing, but we have the right to pick it back up.
Okay.
And so I have to make that decision.
But
They're still unindicted.
They're still currently on.
2 unindicted, correct.
And what about discovery, Mr. Clark?
I sent him discovery, but if he's, we'll pre-trial, I'll get with him and see what's missing.
All right. I'll give you one reset on it. That's it. What? Oh, it's a 2-week calendar. Oh, that's good. Let's leave it on the, I mean, you don't, I heard you, the only thing is I have to leave on the 25th, so I'm not available for next week. Your ace is cold. All right, we'll give it one reset. Position 18, Quintez Jones. He's here.
Good morning, Your Honor. Gerald Briggs on behalf of Mr. Jones. He's in custody. I think we are ready with a retrial judge resolution.
Retrial. Okay. Position 19, Bridges.
And Your Honor, I'm gonna ask, we've been conveyed an offer by the state in discovery as well. I am gonna ask for just one further final plea on this. She does have, I think this was an announcement made previously, another case that was recently indicted, has actually been put in front of Judge Edwards, and she has a private attorney on. They just went for arraignment last, about a week and a half ago, from Judge Edwards, and they're not guilty. So I want to see is obviously, I think the state would probably be interested in some sort of global resolution. I'm not sure if we're going to get there based on the state's initial offer, but at least just the fact that I assumed that it was going to be coming in front of Your Honor, and we would have a chance to see and address that. But I guess I was kind of caught off guard with unfortunate. So I'd ask for one more final plea. Other than that, I'd make the offer from Bridges.
Your state.
Your Honor, yes, based on what Mr. Clark has said, there is another case, and so that is in another courtroom. And we have no issue with it being reset to another final plea, because we would like to do a global versus doing the one case.
And the only other thing I noticed, she does additionally have another unindicted charge that she got it as well. So, I mean, this isn't something that, I mean, we've got a 2-week trial calendar coming up. Isn't there anything that you can get resolved before then?
I think based on where the state's offer is right now, I think we need to have more conversation. I don't want to put too much more on the record, but all right, potentially, yes.
Let's circle back to this one. Is Bridges in custody? She is. All right.
Not on this case. It's on the other case. So this is not the case.
Okay. All right, then I see Marsh is in the courtroom now.
Yes, Judge, good morning. My apologies for my second.
Yeah, no problem. I appreciate you coming over. What are the 2 cases again that you have?
Judge, I believe I don't know the position. I know it's, the group, Eric, the group, as well as Corey Marshall.
Okay, all right, let's do the group. Well, what announcements do you have on the group?
Judge, so one, I do have a leave filed for the 18th, not that whole week, just the 18th. And I candidly to the court, it was only filed on August 25th. A friend called me and asked me if I wanted to go deep sea fishing on a last minute trip. They had a spot. So we filed it as soon as that happens. I'm in full disclosure, let the court know that. Ms. Marsh reached out to me Saturday. Appreciate her reaching out. I think she just got assigned to this. I responded to her. We had some email back and forth. I let her know that I had some outstanding discovery requests, and she got me a link on Sunday. I was on a flight back from town yesterday, so I haven't looked at that yet, but presumably that will contain my discovery requests. I think ultimately we're asking for one reset, so she can get caught up to speed. I can review that discovery, make sure I've got everything I need, and we also have a possible way we can resolve this case, it would require the defendant being transported to Arizona, resolving a probation revocation issue, and then potentially we can work something out concurrent. Arizona cannot by law run anything concurrent to anything we do here. So it puts it in a difficult position where if we can resolve Arizona, I think we can resolve our case.
Ms. Marsh?
Yes, Your Honor, I don't have any objections to that. I'm aware of the Arizona case. This is essentially the 413.
I'm aware of it all. I wrote it.
Yes, Judge. So, I would like to make sure council has all of the discovery. I became aware of those requests over the weekend once I reached out and tried my best to,
What was the discovery you were waiting on?
It's the interviews, the initial interview of the plaintiff and initial interviews of the witnesses that were in the hotel. I had their summaries of their statement, but it would appear all those interviews were recorded. So certainly like to hear those for impeachment purposes and all that will be to proceed to trial.
How does the Arizona fit in again? You want to try to, so he's got a probation revocation because of Arizona, right? I mean, because of this.
Correct.
Is Arizona probation.
I've talked to, I think, an appointed attorney for him out there, and I believe the previous ADA had talked to the prosecutor out there. Based on the standard and the evidence, everyone assumes that he will get approximately 10 to 15 years in Arizona, fairly easily. They cannot run that concurrent to anything here. We tried to get Arizona to come get him, resolve that, come back. They can't get him because he has an active case here. The only way Arizona would come get him is if we agree to a temporary bond. They'll get held here, they'll come get him. While they're getting him, that bond will expire, so they'll still have a hold here in Fulton County, so he'll never actually be out of custody. But I think that's the only way that we can get Arizona to get him, resolve that case, comes back here on the hold, we resolve our case.
Ms. Marsh, you're okay with this scenario?
Judge, in full candor, I need to look into that. This is my first time hearing of that, about 2 days ago, when we initially spoke. That had not been previously conveyed to me. I have no objection to it. I would like to look into and finish the previous negotiations that he was having with Mr. Thomas. But I just need some time, Judge, to see what that Arizona situation looks like at this point.
And Judge, I think we're currently, the state's offer is 25 years on this case, which would be a trial on this case. This case here, and then still have to go to Arizona, but I think if we can resolve Arizona, I do think that will help us resolve this case.
I guess stick around for a little bit. I'm going to call him out. But, all right. What about Corey Marshall?
Yes, Judge. I did hear part of the defense's announcement on Marshall. I also saw that, got notice of that 925 motions date and the October trial calendar. I would like clarification on that, but otherwise the state will be ready to proceed. The information, the motions pretty much contain the same issue. We're trying to put 413 in and the defense is trying to exclude that case. So it should be able to be heard morning trial.
Should be able to be heard what?
Morning the trial.
Mr. Clark?
Yeah, you're right. I mean, I think I concur, in the sense that I think these are pretty standard boilerplate motions. I mean, it shouldn't be a long hearing whatsoever. I mean, as I stated, I'm prepared to do it today, if the court would like to do that. Otherwise, I guess I don't have any issue doing it in the morning of trial. And the sooner we do it, the more, I guess, planning we have for trial to, as far as openings.
Would you be prepared to do it today?
No, we did brief it. I do know that this case is on for a calendar call for Thursday. Perhaps I can try to find someone to do it for me.
Like Thursday afternoon?
I'll have to look and see. I did also hear that it's 2-week trial calendar, so here on the 18th of the next week.
That's the only thing, I believe on this one bit, so.
Yeah.
To try. Yeah.
I don't know if I could. I don't know if it could be heard Thursday. I will not be here Thursday. I will have to find someone else to argue with, and I'm not sure what the rest of my unit's schedule looks like at this time. Or, I mean, I'm prepared to argue it on 9/25 as well, the motion state that we received. And I'll certainly be here that day.
Yeah, but Clark's not gonna be here.
Oh, I'm sorry. I keep forgetting that. I'm sorry. Yes, okay. So I guess we can't do it that day. Is there a day, are you gonna be on that whole week?
Yeah.
Okay.
Pardon me? Well, I mean, Clark doesn't, just a few days before would be nice to prepare as far as, whatever my role is. Can't also do that, let me see here. So what are the motions? You've got the 413. What else?
That's pretty much it, Your Honor. We filed a motion to introduce 413 evidence, which is the same case that he's trying to
Exclude, yeah.
And I think there was
I may.
and then there was a standard brief shield motion that, that's just, I mean, that's just very brief argument, so.
Good luck here. Good. Looking at some stuff here. So the days, we got the final plea, we got the cases, we get the stats. When are our in-person days again, Kathy? Yes, maybe like Wednesday. Yeah. Or Friday. All right, why don't you? Pardon me? Well, we're getting to that. Can you all do it on Friday?
I'm available on Friday.
So Judge, what is happening is, before I came here, I had to leave in another courtroom from
Yeah.
Wednesday to Friday. That was in my trial division. And so that is the reason why I will not be here for the rest of the week. So it's kind of the same announcement from before.
Can't get somebody to sub one of those days?
I will have to see. I just don't want to make that statement to the court without.
All
knowing
right,
for
why
sure.
don't you see, and Kathy, why don't you talk to Kathy about it, all right?
I will, Judge. Thank you.
Okay, thank you. All right. All right, I think that's it for right now.
Good morning, Judge. I'm Andrea Roberts for Mr. Gibson, Shay Gibson. Skipped over him when I was here.
Oh, co-defendant with who?
Kenneth Miller.
Okay. Discovery, been served. Been in talks, discuss. Oh, so you're here just to pre-try, right? You're gonna pre-try?
His actually may be a We may be ready for a plea. We have an offer from the state on his.
Well, yeah, that's what I meant. So
yes,
what, okay, all right. So is there anybody else that has anything to say before I take a break? All right. I'll take a break. Oh, wait a minute. Hey, let's bring out the group. Let's go ahead and bring out the group before so Mr. Acuff doesn't have to sit here much longer. No problem. I mean, yeah, but she's here. She's going to try to work on her deal too, right? All right. With Mr. Millen. All right. How many positions we have tomorrow? 33. Who? Oh, Duval. How do we leave Duval? Oh, that's right. I don't know how we send that trial without having noticed it. Yeah, but what about the attorney? Yeah. Well, we'll talk about that in a minute. We'll talk about that. All right, so this is 21 SC 179-653, Eric John DeGroot, who's accompanied by his attorney, Mr. Acuff. We have Ms. Marsh with the ADA. So Mr. Acuff, what were you discussing as far as the Arizona?
Yeah, Judge. So with one of the previous ADAs, Mr. Thomas, we had tried to get the defendant to Arizona, transported there while in custody so that he could deal with his revocation first. He's got some revocations pending for a few different matters in Arizona. And talking with the state in Arizona, one, they could not transport him because he has a pending case. So there was no way to get him there with this case still pending here in Georgia. And two, they cannot run any of their revocation time by law concurrent to anything he gets in a sentence here.
And you're saying that the lower standard on a revocation in Arizona, it is your belief that whether he is regardless of whether he is convicted here, it's going to more likely be the same outcome in Arizona on that revocation?
That's correct, Judge. I think one of the revocation issues is him leaving the state in the first place, being in Atlanta, which there's going to be very little defense for. And the way the charges work in Arizona, my understanding is that there are very significant penalties for violations of probation there, which just being out of the state or being on a electronic device could be one of them. So regardless of the pending case here, I think he's got some serious legal issues in Arizona after talking with his appointed attorney out there, let alone the case here. So I don't think that a conviction here will necessarily impact how much time he ends up getting in Arizona on a revocation. But they cannot run their time concurrent. So there's no way to do a global resolution with them if he pleads here first. Okay. Anything that he gets there would have to be consecutive.
Ms. Marsh, I know you're saying you're just getting hit with this, but I assume anything that involves giving more time you're in favor of as far as resetting and the likes.
I have no objection.
And I understand Ms. Marsh. I certainly understand Ms. Marsh will want to vet this and make sure that it will work. But the only idea I have of getting him out there would be to consent to a temporary bond here
Well, that sounds like something that you and Miss Marsh probably need to
Right.
discuss, but I will let's reset this for another 30 days and just put it down for a status or something. Okay.
Understood, Judge. And I'll get with Ms. Marsh, make sure I've got the discovery, so that if it doesn't work out, we'll be ready to go.
Okay. All right. All right. You're excused.
Thank you.
All right. And then, so Ms. Duvall, let me pull you up here. Oh, it's Miss Hill. I'm sorry. Your client is Duvall. I mean, I'm getting it in the ballpark at least. I'm getting, so Duvall, why don't you pull out, why don't you bring Duvall out? Yeah.
Thank you, Judge.
No. Is that like it? The ball is yours. It's kind of. Okay, okay.
Your Honor,
Yes.
for this particular case, it is, crimes against children. So I've been asked to have, asked for them to hold for, their announcement on, as they are in another court right now, Judge Barwood.
When are they gonna, so what, 30 minutes, an hour? What do we?
An hour.
All right, well, then I'm gonna take a break and, all right.
Today it will be, Attorney, Julian Jordan. He'll be,
Oh.
yeah, he'll be filling in.
I mean, every announcement on somebody from the AD's office that needs to be proceeded with today, it will be,
Judge, may I be excused for an hour then? I have another matter I need to go see about.
Sure.
Thank you.
sure, as long as you stay within our orbit, you know.
I will be in the orbit.
Okay. All right. I'll be back in a minute.
Hey, Ms. Hill. Hill still here? Can you give your cell phone or something to Kathy, just so if we're ready, at least you can text her or whatever.
I mean, the offer that I made was appropriate. Based off of what it's fresh. Now, you have an alternative proposal? No, I just want to be able to. Okay. I mean, I'm willing to do something where, he's what been in custody with, how long? 509 days, so I'm willing to do, possibly do.
So Tony, I think you and I have cases, right?
Huh?
Two, right?
Do an ankle monitor for 2 years, sure. But it's gonna have to be special conditions, like he's gonna have to have a curfew. Okay. Yeah. But for the first 2 years, yeah, I'm fine.
So are you talking about?
So how many days?
Mr. Briggs,
So 590,
before the plea or something? I don't think that.
Oh.
Well, I'm willing to give him,
Oh, yeah.
Yeah. 2 years, well, I'm willing to say.
Commuted to time
Yeah.
served.
Commuted to time
Oh,
served.
okay.
Yeah.
All right, I'll get them.
Yeah.
Christina.
Yes.
I'm so confused.
Okay.
Christina.
Just 1 second, all right.
So we'll just.
I'll be right here. One second. Mr. Tank. Okay. So find the email while responding to Ms. Gilbert's name.
Oh, yeah.
I had.
Yeah, please.
Let's hold.
Okay, all right.
Kenny, let's hold the agenda.
Okay. Okay. I'm sorry.
I guess. I need.
They were like, both of this one and this one. Okay. So we're trying to do, well, this, once this is all, this will be on. That's why. Okay. What else? I believe, yes. Okay. And Tanya, you wanted to, Jamal already reset that, right?
No, I wanted to talk to you about that.
Yeah, that one.
No.
That is it for right now, but I'll let you know. Yeah. Yeah.
Yeah.
He's almost done 2 years.
He did get shot.
When? Eric Parks, or is it talking about the other guy? The other guy got shot. Let me check. I'm getting, I think that I'm doing the same. Yeah, she's pissed. I talked to her this morning. Yeah, he didn't get shot. She didn't. He hit her with the butt of the gun, and then he beat her ass. Because the other guy, Jamal, whatever, he was engaged in a shootout, and then they shot back. But I don't know. Oh, I remember this case. Yeah, he's almost done with it. He should just very reasonable. She had a swollen left eye, multiple lacerations on her head, her neck, and her back area. She could not see clearly. Her voice was raspy due to him strangling her. That's right. She left because she was worried about her children. That's right. She wanted to make sure they were okay. All the police knew.
Right, so he'll be, yeah, so they'll be, okay, yeah, okay.
All right, you said.
I'm gonna email.
All right, I want to talk to them.
All right.
They're in the back there.
Are they? Okay, so I think you can just tell them that you need to talk.
Okay.
Yes.
So the intent was.
Yeah, Mr. Parks.
What?
Eric.
Shot on the left arm.
That's not Mark. Is that the same case?
Yeah, it's January 26th, so,
Oh, okay, hold on. Let me see.
my understanding is Mr. Johnson.
So.
That's right. It was a separate. It wasn't a separate incident. Yes.
Yes, I understand.
Yes. By her, yeah, because after she told him, she told her boyfriend like he whooped my ass.
Well, I know, but that's mitigation.
Not really.
But it's.
So then he could come back and then it's our business again.
I'll be with you in a second.
What? I don't know about that, but let me check. I want to see how many days he has left. We did the 712 minus. It's like 154 days left. So if he did it, he would take just, if he went to this, it'd be 154 days.
Yes.
All right, so then, you know. That's why I see.
Is he, and the restitution is a big one. He's gonna give that back.
I'm just saying.
That's what I'm saying. And then this case. Yeah. So I don't care about position marijuana.
No, but I mean,
Oh, let me look at it. Let me look at it.
Right when this happened. Because I've never been told.
So GC? Why?
just easier to reach.
Oh.
And all those cycles, we really shouldn't.
Yeah,
Yes.
it was bound over to state court. I don't even, I think it was pre-trial release and nothing. Yeah, not on docket, nothing yet. And the state court told me. Well, yeah, I kind of have to do the two because of her injuries and how bad it was. Okay, let me think about it, talking about the other one. Boom. I didn't even know it was my case until seconds.
I don't have any of the body cams.
Okay. You don't have any body.
Yeah, but I just wanted to talk with this.
How are you doing, Mr. Jones?
My office has, I have it.
Good to see you.
No, I can find out.
So I asked the court to hold for your the defense attorney, Rhonda Hill. She said something about she had to come. This, okay, so Lauren emails that you should see.
And so I've had my
They
investigator
belong
try to reach out to some of the family members, but I don't know if it's not giving us good communication. What they're trying, which.
I mean,
it could happen.
I would, really, they avoid you, the public defender, who's trying to help it, the family members?
I'm just saying what my investigators are doing. So it's all guessing.
This is what I kind of remember about.
They don't want to get involved, so unless you get them on the phone, like.
Or like he's making up numbers because of, yeah, bad numbers, like because competence.
When she responded on to like a group, if I was especially in her turn to say, Larry Sanderson. I think she just forgot.
Barner.
I'll text you.
Kevin
Okay.
Yeah, Lauren was just. she's already-
Kevin Barner, why does that sound familiar? Yeah.
Right, it is.
So
Yeah.
I'll text
He's
you.
the guy who-
We went back upstairs. Lauren, we're approaching the status.
Is that my
I'll hit
case?
you back and forth, but
Okay.
when you-
Sister should not be a
Well, I
DV.
told him that the whole-
It kind of, it reminds me a lot of that because.
For them to hold for an hour.
Okay.
Yeah, so an hour, that was probably about 15 minutes.
Okay, I appreciate
Yeah.
that. So here's.
Just kept talking about good.
Right, and I will, and if you're not here, I will say.
So what do you wanna do?
And I'll
Let me
just text
talk
you
with him. I was just
and
curious
ask
if
them
you
to
had any
continue.
backstory.
Gotcha, thank you so much.
Yes, sir.
Do you want to offer,
Good
Hey.
Miss Carr. Hey.
Yes, hey.
or you want to do the competency first?
I know she's interested in resolving. She's got that.
Right,
Just really trying to
um,
figure out what's the right-
Yeah.
but
I gotta double
We can
check.
talk to
Okay.
Kathy after.
Alright,
and
Janet
talk to them, because I
No.
do want to make sure you
Okay,
get the body, so we can.
So-
Yeah,
reset
I'm
that.
just curious to see even what.
So
his
let's just reset it so you can do the
Yes.
eval, and then I can
Let
get you the body
me-
cam.
Demeanor is like.
Yeah.
let me send something, finish the email up, and let me send something out now. Yeah.
What does that mean? I don't even know. Yeah, hence the DV.
Right, so you see what, you see
They
my.
lived together. They previously lived together. Yeah, we even talked to her mother. Mother was like, she was having, so this is one note I have. She told me that she was having surgery. She was in the hospital. And then she was like, is she okay? Yeah, that's really normal. Because of the injuries.
Something like that, gives me a little bit more,
Yeah,
what's the word? Firm ground.
firm ground, there you go.
Give me a second, give me a second. Yeah, I'll cover.
All right, Mr. Harden.
Okay, I'm about to send it to you now. I'm listening. You want it, so the offer would be, the offer would be. So I was thinking of doing, like 4 years, 1 year, community time served, probation on the rest with special conditions, ankle monitors first 2 years, and paid for, I mean, it'd be expensive to state, and then also, would be, drug eval, treatment if necessary, reimbursed screens, gainful employment. Yeah, that's actually listening.
It's okay, so to personnel, but wherever, county that is, Chatham. So. It looked like too, that 2002 Chrysler.
Yeah, but the book value of it was $1,700. So, I mean, yeah, the serve and discover. There you got it right there. You just flip it over. It's the Audi.
No, not the Audi, sorry. I'm talking about
The van.
Chrysler, yeah.
Pull up evidence.com.
I can go. I just know that. I don't get to say that very often, but when I do, I like.
I got you on the, but you know, like, why he has a number of convictions, so.
Well, so does your star witness, Mr. He's got. He's got 41 cycles. Yeah. Is that?
Clearly he's got some issues.
Huh?
So clearly, that's
Yeah.
all of his theft. It's
He's got some
clear.
issues, and he just appointed himself, police to Mr. Hartman, that's all, that's. Like, Judge.
Wait, what was the, what was it?
Drake actually dismissed it.
What was the,
No, it was more than that. They had more than that. The officer, they also had the testimony of the person that
Sure, he
owned
had
the.
been there, but he'd been on that, and he was a known person on that. And that was circumstantial at best, but you can't call Mr. Carroll in. Several.
Mr. Carroll, but I'm saying the person that he actually tried to pass off the vehicle too, in order to get it. We have that person to testify.
But the star person is Mr. Farrell. He's the one who corrected police to Mr. Hardin. Yeah, stop 40%.
Right, but he directed them, but then it was like, it was cooperated by the scrapyard place that he tried to sell it to, and he tried to falsify that, which is why he was charged. So,
The scrapping is for the Chevy, not the Audi.
right. So which case are you talking about?
They're both intertwined. Okay, so the Audi one, which is found in Chatham County, really, the only.
Coweta
real-
County. Mm-hmm.
The only real concrete evidence you have.
What do you not have, so I can make sure?
The two people that.
And then the other case.
The police
is
report says that they
the
took pictures of their
Town and
injuries.
Country.
I don't have
which
that,
isn't
I don't
even
have any
worth,
body, yeah, I just have the
They
police
take
report
three
at
hundred
this point,
ninety-five
so.
dollars from the
if there's
owner. I'm
911
guessing they were gonna
calls
scrap it.
or-
That was stolen either that night or the night after, and they see two men who did not necessarily see who's necessarily on that video. So, but, I mean, I'll talk to him.
I mean, you know, if you want to go to trial on it, that's fine. I mean,
Well, I'll be ready next.
Yeah,
that's for
okay.
sure.
you know,
Nice little case tomorrow.
yeah. Sounds good.
Did you send that already? So I can just show it. to him?
I was about to send it,
Okay,
but you,
perfect.
you.
Well, we're talking.
Right, and so that's what I stopped, and I'm about to send it to you now. Give me a second.
Wait, I mean, nothing to hide here. In the state, I can't hide anything.
Yeah, 57 cycle.
Is that right?
Case number.
Yeah, because that's on evidence, that's how I have to pull it up on, so like, yeah. I'll put the case number. Well, that's because that's all I have.
Okay,
Let me request all that.
okay, all right.
Definitely, thank God this is a reset. Can this be reset for 2 months instead of 1 month? Just check the gas. You don't care? Okay. That way I can get everything. Okay, so we need body cam photos. What else? 911 call. Okay, so let me request that right now. Thank you for bringing that to my attention. Both tomorrow and one's a bond hearing in Cox. So I'm just like, I don't even know what I'm gonna do. I'm gonna have to get someone to cover for me tomorrow. Or
Here?
Cox, no, not here. Here's a final plea and I have some cases on there.
Oh,
So it
gotcha.
has to be Cox.
Yeah, but it'll.
Yeah, it's true.
Are they ready? Oh, okay, okay. I will wait a minute.
Once y'all sign, we can go ahead and get.
So.
Yeah.
Move forward?
Yeah. I mean, we started the process, I can, for tomorrow, yeah, so I mean, last time, I don't. Supervisor was, and then, so, and then.
Our
then-
issues, yeah.
Yeah, you could say they should counter that we need this, and we're working on making it happen, and I think that's, from my perspective, so, let them know we're working on it actively.
Right. Perfect. When my supervisor threw out the number 5
Okay,
to serve.
well, I'll start having that.
Yeah, but, and so, yeah, my biggest, I want to make sure that, I don't think it needs to be a reporting, charge. So I just verify that, and she said that, my supervisor. Oh, that's why she kept the case. She just said, she was disciplined. So she. Yeah, some of there's some bleeding.
Right. Unrelated matter. Send an email, a couple emails on.
Dawn?
We have filed to amend the bond to Chinese surgery. And if we just get
She was like violating the bond condition. There's a screenshot of the phone I received, all I received from my husband. This is in June. This is in June.
My understanding, she's filed.
Yes, screenshot, I'll send this to you. For
Mine gets surgery. I just told her.
I also don't understand people.
Oh, a lot of layer, another layer of funness.
Yeah.
Fun.
And then you're like, okay, this is not the place to hash out the divorce.
I want that broken plate. You're not getting it.
He's not getting his plate back.
Yeah,
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 Mr.
yeah.
Jones does.
Yeah.
Yep. But
You go.
Miss Kathy, have you ever been back there?
Oh.
not tasteful.
With apples and oatmeal.
What is that? Apples and oatmeal?
That's what I thought she said, but apparently it's a new Yes, ma'am. Yes, ma'am. Okay. Okay.
And I'm only answering. You know. Because I think I'll ask. Okay, no problem. Okay. No problem. Yeah. You have a good day.
There.
Yes.
See here. Quintez Jones.
Do inmates have internet access?
Who?
Inmates have internet access? But
You
your client met this girl when he was in jail on Facebook.
Listen,
So
it's a lot
clearly-
of things going on in the prison system. I have
Clearly
no
we got Facebook
representations on
hacked.
whether or not
Clearly, we got
people
Facebook
have
hacked.
access to the
Good morning,
internet.
sir. Morning, how are you? I thought that, I took a tour of the jail. I thought there was a special area for inmates that were very well behaved that had some sort of iPad access, but maybe I'm wrong. I think it's heavily monitored, though. I don't think you
I
can just
mean,
have free for
clearly
all.
not when you're having really on Facebook getting into relationships.
Well,
Anyway,
Yeah.
side note.
yeah, I was gonna say, that's not here nor there, but how are you, Mr. Griggs?
I'm doing great, Judge. How you doing?
All right, so this is 19 SC 170972 Quintez Maurice Jones, who's present in the courtroom with his attorney, Mr. Griggs. And we have Miss Iqbal with the district attorney's office. Miss Iqbal, you've got a negotiated plea to present.
Yes, Judge.
Go ahead.
Sir, please raise your right hand. Do you swear or affirm that any evidence or testimony you shall give in the matter pending before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can lower your hand. Please speak up. Please state and spell your true, correct, and legal name.
Quintez Jones, QUINTEZJONES.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication you normally take that you have not been given today?
No, ma'am.
How old are you, sir?
31,
And what's the highest level of education you've completed?
12.
Are you
Okay.
able, are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you've been charged with the following offenses? 1 count of aggravated assault, strangulation, and 1 count of battery.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the waiver of rights form with your attorney?
Yes, ma'am.
And did you sign the waiver of rights form?
Yes, ma'am.
And did you review the indictment form with your attorney?
Yes, ma'am.
And did you sign the indictment?
Yes, ma'am.
Your Honor, this time state moves to tender in the waiver of rights form and the indictment form into the record.
So moved.
And sir, have you had enough time to speak with your lawyer about all the charges in this indictment, including the facts and circumstances related to these charges?
Yes, ma'am.
Would you like any more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with his services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
Yes, we do.
And counsel, do you waive any and all defects in the indictment, including any with respect to his name?
Yes, we do.
And sir, has your attorney advised you the minimum maximum sentence for each charge that you're pleading to?
Yes, ma'am.
So you understand aggravated assault, the minimum is 1 year, the maximum is 20. Battery is a misdemeanor, the minimum is 1 day, maximum is 12 months. You understand that, sir?
Yes, ma'am.
Okay. Do you understand today you're entering a negotiated plea of guilty, which means that the state and the defense will jointly recommend the following sentence. For count 1, aggravated assault, 5 years of probation. Special conditions of probation: must complete a family violence intervention program and have no contact with the victim. Count 2 is the battery, would be 12 months probation to run concurrent with count 1, Your Honor. Sir, do you understand that that's what the state is recommending to the court?
Yes, ma'am.
Do you understand that the court is not required to accept this recommendation, that the court has the right to sentence you on to the maximum possible sentence on each charge?
Yes, ma'am.
And run those consecutively, meaning one after another.
Yes, ma'am.
Are you parole?
No more. I'm done with probation in another county, but no, ma'am.
Okay. Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit? You understand that, sir?
Yes, ma'am.
And do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes, ma'am.
And then you understand that if you fail to follow all the special conditions of your probation, you'll be subject to revocation of that probation for the balance of your sentence.
Yes, ma'am.
And you understand that you're not allowed to possess or use a firearm while on probation.
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, ma'am.
Do you understand doing so will result in new criminal charges for which you could face a sentence of between 1 and 10 years?
I understand, ma'am.
Do you understand that by pleading guilty to a felony, you may also not use a firearm in a crime in the future?
Yes, ma'am.
Do you understand that if you were to use a firearm in a crime in the future, you could face up to a 15-year custodial sentence consecutive to the underlying felony?
Yes, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
And do you understand that by pleading guilty, you're giving up the following rights? The right by trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena any witnesses on your behalf, the right to testify against yourself or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial. Do you understand that, sir?
Yes, ma'am.
Is it your decision to waive these rights, which means not to use them and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, coerced, promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you're in fact guilty?
Yes, ma'am.
As to indictment number 19 SC 170972, how do you plead to the charges of aggravated assault and battery?
Guilty.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days of today's date?
Yes, ma'am.
And do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition, and you only have 4 years from today for the felony charge and 12 months from today for that misdemeanor charge to file that petition? Do you understand that, sir?
Yes, ma'am.
Your Honor, had this case gone to trial, the state would be able to prove beyond a reasonable doubt that on December 29th, 2016, officers were dispatched to 60 Pascal Boulevard Northwest, which is in Fulton County, Your Honor. When officers arrived, they made contact with the victim, Miss Cassidy Phillips, Kassidy Phillips. She stated that her boyfriend, the defendant, she met him on Facebook when he was in jail. They started a long-term relationship, and so she went to visit him for Thanksgiving. During that time, argument occurred. She wanted to leave, and that's when the defendant punched her multiple times and also strangled her, put his hands around her neck and strangled her. Officers were able to observe injuries. She was able to leave and out the apartment and get help from neighbors. And so she did have injuries and was seen by Grady and taken to the hospital. This defendant has 2, I believe, criminal, one moment, let's see, 2 convictions. Yes, Judge, I believe he has, pardon me, I lost it. He has a kidnapping from 2018 and a false imprisonment from 2016, Your Honor.
Okay.
I've spoken with the victim. She's okay with this. In fact, she's on board because she doesn't live in the state and has no contact with him and wants nothing to do with him.
All right, Mr. Griggs.
Judge, we'd simply ask that you follow the recommendation. It's been thoroughly negotiated and Mr. Jones is accepting accountability.
Mr. Jones, do you understand the nature of the charges against you?
Yes, sir.
You just heard from ADA Iqbal explain all the rights you give up by earning this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes, sir.
Do you understand the court is not bound by the recommendation of the plea agreement? I can sentence you as I deem appropriate.
Yes, sir. I understand.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
Mr. Griggs, are you satisfied that your client is competent and understanding the plea is voluntary and there's sufficient factual basis for entering the plea?
Yes, Judge, I am.
I find there's sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. I'll accept your guilty plea and sentence you to the recommended plea as follows, which is count 1, 5 years probation, special conditions to complete upon release to complete a family violence intervention program. Can he do that in 12 months?
I think so, but he does have another matter in Paulding County he has resolved first.
I resolved it. I'm sorry.
Well, I'll say complete within 12 months upon release, whether it's here or Paulding County, or completed in 12 months and no contact with the victim, Cassidy Phillips. Anything else?
No, you're
Oh, wait a minute. The second charge is 12 months probation to be concurrent.
yes.
Is that concurrent or
No,
consecutive?
concurrent, Your Honor.
Concurrent, 12 months probation.
A total of
concurrent.
5 years,
Total of
5 years of probation.
5 years probation, concurrent. Okay.
Thank you, Judge.
All right, you're excused.
Douglas, that's right. I'm sorry. Okay. Judge, that concludes my business. May I be excused?
You're excused, Ms. Griggs. You're right. Timing it, huh? So should I take a break? That's all right. I'm all right with that. I'm all right with. As long as she asks somebody.
Just to let you know, I am special set, or not special set. There's a speeding talks on the 25th that I'm like, just.
Are you telling me this because of Kenny?
No,
Why are you telling me this?
because we told me to talk around those 2 weeks. I didn't. I didn't know I was be available.
What do we have potentially with you? Okay.
More information, federation.
Yeah, well, so much it pushes important stuff out. Not that you're unimportant, I say, Paul, but. Should I wait here for a little bit or do I need to? I feel like more gets accomplished when I'm not here, so. It was an announcement, I thought, from Mr. Jordan.
Yeah, well, I didn't know if you wanted to bring out.
You want to bring out your client?
Yeah.
Yeah, all right, bring out your client. Duval. Can you pre-try? You mean with me or? Sure. I mean, do you want me to step out? I'm fine with stepping out. I mean, like I said, more things get accomplished when I'm not here, so.
That would be good. Let me step out, okay?
All right, let me step out. How are you, Julian? Good. All right. Step out.
It got locked somehow.
I'm trying to choose.
Okay. Okay. So both this and.
Oh.
Oh, I gotta talk to Jamal. You're not quiet. This is what I do. Post, you know, the ones that are like around the church.
Miss Kathy.
Oh.
Yeah.
Okay.
Oh, girl, I'm sorry.
Playing with it. All right, so.
Oh. Yes. Yes. What about the fire?
I'll talk with them about the fire. Even just forestry. Yeah, he's been in 18 months, I think. I can talk to him about that.
No. I'm not ready. Oh, okay. Right here. Yeah.
I've got two kind of counter offers going. Yes.
Yeah. No.
Okay, yeah, okay, all right. Okay, so I
People like you too, don't worry.
I'm like, I heard you guys like me. We will.
Yes, ma'am.
Okay, but she's very much still a restitution.
Absolutely.
Okay. And then we'll. And then.
I just want to make sure. Because maybe,
He might.
maybe, no, maybe he's all of a sudden he's become healed. Oh, that's not appropriate.
You're the opposite, aren't you?
I always am.
Page older than one.
Right?
No, I got it first. Yeah, they also use.
Hey, Robert, I just sent it to you.
We're good. We're good. One step closer.
What's that for?
She might be a little firm on the ground. There's others,
Yeah.
We have a copier in our office. It never works. So they service it and it does copy runs and then it just. Why don't they just replace it? No, it's, you know, one of those monsters. Bad, you know. always worry about friends.
No, no, as long as. It's not the chick, not the child. Okay, so. So then we. Number. Yeah, I need her address. I don't know her address, I can give you her. Okay. That's the only way. Okay, so let me confirm to her. Okay. I'm gonna get her out. Okay, okay. I didn't see it. I wouldn't. No, they don't do it. I don't know what you said.
Yeah. Yeah.
Yeah.
there's a. I think that's. I know, I had never received all of this on last month. Yeah.
Yeah, is she ready? You print it out? I emailed you. Print that out for me. This time.
Yeah.
I think that's right.
Yeah, I mean, I was just.
Yeah.
Yeah.
But that other thing shows just this.
Yeah. Okay, cool. That's fine.
So that's all, so that's all.
And then we've already.
It is a very,
That
old
is
one,
their website.
and I got your email. So I can give you a call afternoon maybe.
Okay.
Yeah.
All right, sounds good. Yeah. Okay. What kind of? And milling is gonna be a pretty. Is it the same? Your sentence. You're gonna be the same sentence. Okay. I think.
Colors. Who sent you her name and information?
Okay.
Miss Roberts, her client, so it would be, I think, Millen. Oh, Gibson, sorry.
Yeah. What, I mean, we're doing one plea at a time, right? Yeah, yeah.
No, ma'am, she did not. Attorney Bumpus. Ms. Robinson is inquiring about your client's paperwork for the plea.
Sorry, trying to find the unmute button. My client's paperwork, I gave it to the deputy. Hello, can y'all hear me? Hello?
Okay.
Can y'all hear me?
Yes.
Oh, okay.
Are we ready or see? Oh.
Quick.
All right, is this Gibson?
Yes, sir.
Okay. And you are Miss Roberts?
I am.
Okay. All right, so this is 22 SC 184195. Deshae Gibson, present in the courtroom with his attorney, Ms. Roberts, and we have Ms. Clark with the ADA Clark with the District Attorney's Office. And you have a negotiated plea to present, correct?
Yes, Your Honor, the state does.
Go ahead, Ms. Clark.
Defendant Gibson, please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
You can put your hand down. Please state and spell your true, correct, and legal name.
DASHAE.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
Trimate.
I'm sorry?
Trimate. TRIUMEQ.
And what is that medication for?
HIV.
And is it prescribed?
Yes, it's prescribed.
Does not taking this medication impact your ability to understand this proceeding?
I'm not sure.
What, wait a minute. So you're talking about the medication? Is that, you were asking about his medication and whether it
Yes.
impacts his ability to do this plea? Ms. Roberts?
I've spoken with Mr. Gibson. Do you understand? She's asking, do you understand everything that's happening today, despite the fact that you haven't had the medication?
Mhm.
You have to answer yes or no.
Yes.
Okay.
Well, I mean, let's dig into this a little bit here, because your client just said that he was unsure because he has not taken his medication today. I mean, how does that medication affect your ability to understand this plea and understand the waiver and understand what rights you're giving up and understand what you're agreeing to, Mr. Gibson?
No.
It does not?
No.
Okay. All right. Go ahead, Ms. Clark.
Okay, so there are some follow-up questions.
Yeah, and if you want to continue.
Attorney
obviously.
Roberts, based on what your client said initially, do you have any competency concerns?
I do not.
Defendant Gibson, how old are you?
28,
What is the highest level of education or the last grade you completed?
11,
Where did you go to high school?
Darrell High School.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you've been charged with the following offenses? Count 1, conspiracy to commit a burglary in second degree. Count 2, conspiracy to commit burglary in the second degree. Count 3, burglary in the second degree. Count 4, burglary in the second degree. Count 5, theft by taking. Count 6, possession of tools for commission of a crime. Count 8 of the indictment, theft by taking misdemeanor. And count 9, giving false name, address, or birthday to law enforcement officer.
Yes, I understand.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
I plead guilty.
But do you understand, though, that you do have the right to plead either guilty or not guilty?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the waiver of rights form with your attorney, Attorney Roberts, as well as the indictment in this case?
Yes.
And did you understand the waiver of rights form that was explained to you by your attorney?
Yes.
And is it your decision to waive your rights today?
Yes.
And did you sign the waiver of rights form with your attorney?
Yes, ma'am.
And the indictment, Attorney Roberts, did she review the indictment with you?
Yes.
And you understood that you were signing a plea of guilty on that indictment?
Yes.
And you understood that you were signing it?
Yes.
Okay. Your Honor, at this time, the state moves to tender both the indictment signed by the defendant and his attorney, as well as the waiver of rights form into the record.
So moved.
Have you had enough time to speak with your attorney about all of the charges in the indictment including the facts and circumstances relating to these charges?
Yes, ma'am.
Would you like more time to discuss this case with your attorney, Ms. Andrea Roberts?
No, ma'am.
Are you satisfied with your attorney services?
I am.
Attorney Roberts, do you waive a formal reading of the indictment for purposes of this plea?
We do waive.
Do you waive any and all defects in the indictment for purposes of this plea?
Yes.
Your Honor, the state is unaware of any outstanding warrants related to the charges within the indictment. Defendant Gibson, do you remember having been arrested on these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
For the record, the state will provide those. For the conspiracy to commit a burglary in the second degree charge, the minimum is one day in jail up to the half of the time of the penalty, the highest penalty of the crime. Burglary in a second degree carries a maximum of 5 years. So the maximum that you could plead to on this particular charge is half of that time. So the state could not agree to more than 2.5 years on that particular count. For conspiracy to commit a burglary in second degree, same charge. So you cannot plead to a sentence that's more than half of 2.5 years on that one. For burglary in the second degree, count 3, the minimum is 1 year in prison, the max is 5 years in prison. For count 4, same charge, burglary in the second degree, it's 1 to 5 years. For theft by taking, based on the value of the item, the minimum is 1 year, the maximum is 5 years. For possession of tools for commission of a crime, the minimum is 1 year, the maximum is 3 years. For theft by receiving stolen property, that's count 7, that is not your charge. For theft by taking, which is a misdemeanor charge, count 8, the minimum is 1 day in jail, the max is 12 months. And for count 9, giving false name and birth date to law enforcement officer, the minimum is 1 day in jail, the max is 12 months in jail. Is that your understanding?
Yes.
Do you understand that today you are entering what is called a negotiated plea of guilty, which means that the state and defense jointly will recommend the following sentence to the court? For count 1, conspiracy to commit a felony, the state's recommendation is 2 years confinement commuted to time served. For count 2, a conspiracy to commit a felony, the state's recommendation is 2 years confinement commuted to time served. Count 2, it runs concurrent with count 1. For count 3, burglary in the second degree, the state's recommendation is 5 years, 2 years to serve in confinement. This time will be commuted to time served. This sentence will run concurrent with count 1, plus the special conditions of probation as listed below. Count 4, burglary in the second degree, 5 years is the recommendation, 2 years in confinement commuted to time served, concurrent with count 1, plus the special conditions of probation as listed below. I will review those at the end. For count 5, theft by taking, state's recommendation is 1 year confinement commuted to time served, sentence runs concurrent. Count 6, possession of tools for commission of a crime, state's recommendation is 1 year confinement commuted to time served, sentence runs concurrent with count 1. For count 8, theft by taking, misdemeanor, 12 months confinement. The sentence is to run concurrently with count 1. Count 9, giving false name, address, or birth date to law enforcement officer, state's recommendation is 12 months confinement, sentence to run concurrently. The special conditions of probation are as follows. Defendant has a no contact order for the victims in this case, and he must remain at least 200 yards from them at all times. Defendant is prohibited from contacting any victim on social media or via a third party. Victims in this case are Daryl Marvin, June Rogers, and Samantha Adams. Defendant is required to stay away from the incident location, which is 2033 Monroe Drive Northeast, Atlanta, Georgia, and Fulton County. Defendant must have no contact with his co-defendants in this case, which are Kenneth Millen, Royce Bell, and Darius Turner. Defendant must be evaluated for drug and alcohol abuse issues within 60 days. Within 60 days, he must complete any treatment if recommended. The evaluation should occur either prior to his release or at his first day of reporting to his probation officer. Defendant must wear an ankle monitor for the first 2 years of his probated sentence. Upon his release from Fulton County, ankle monitor will be paid for by the state. For the first 2 years of defendant's probated sentence, he is subject to a curfew of 8 p.m. to 8 a.m. and he is only allowed to attend the following: work, school, religious faith services, meetings with his lawyer, medical appointments during the day and or during the curfew period. A work schedule must be provided to his probation officer. Defendant must attend weekly NA meetings for 18 months. After he's released from custody, he must provide proof of his attendance to his probation officer. No drugs unless prescribed and no alcohol. Defendant shall be subject to random drug screens. Defendant must be gainfully employed within 60 days of his first reporting day to probation. And he must remain employed the entire time he's on probation. The defendant will have, again, 60 days. Gainful employment is working a minimum of 40 hours per week as gainful employment. Is that your understanding of the terms of the agreement?
Ma'am, yes, ma'am.
I'm sorry, I didn't hear you.
Ma'am, yes, ma'am.
Okay. And for the record, Your Honor, the state has emailed terms to Attorney Roberts, as well as to you, Your Honor, as well as to the court reporter and Ms. Robinson. Do you understand that the court is not required to accept the state's recommended sentence?
Yes, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge within this indictment?
Yes.
Do you understand that as there are multiple charges to which you're pleading guilty today, the court also has the right to run those sentences or counts consecutively, meaning one after the other?
Right.
Huh?
Yes, ma'am.
Okay. Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, and this is the most important part, you do have the right to withdraw your plea of guilty?
Okay. I understand.
You understand? Okay. And I'm asking you these questions because as a prosecutor, I'm required to make sure that you understand these rights, okay?
Yes.
All right. Are you currently on probation or parole?
No.
Do you understand that if you were on currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yes.
Do you understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
I am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes.
Do you understand that doing so will result in new criminal charges for which you face a sentence of between 1 and 10 years?
Yes.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes.
Do you understand that if you were in the future to use a firearm in the commission of a crime, you would face up to a 15-year custodial sentence consecutive to the sentence for the underlying felony?
Yes.
Do you understand that as a convicted felon with this plea, you will never, ever be able to carry a firearm even after you are on probation? You understand that?
No.
Okay. Would you like time to confer with your attorney?
We're ready to proceed, sorry.
Okay, so again, my question, do you understand that as a convicted felon, you will never be able to carry a firearm even after you are off probation?
Yes.
Do you understand that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
No, I didn't understand.
You understand that question?
Well, I understand what she's saying, but I don't understand why.
So what she's saying, once you have people, okay.
So I'm still going to trial basically.
No, so you won't be going.
I'm not going to try today, saying further.
You want this will end your case today. Understand?
Not being a case like through the judge.
Yes.
I understand.
Okay.
Can you re-ask it, Ms. Clark?
Yes, Your Honor. Do you understand, Defendant Gibson, that by entering a plea of guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes.
I'm going to ask you a lot of questions, but you only have to respond at the end. Do you understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena any witnesses on your own behalf, the right to testify against yourself or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Is it your decision, Defendant Gibson, to waive these rights, which means not to use any of the ones I just read to you, and to enter a guilty plea today?
Yes.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
As to indictment number 22 SC 184195, how do you plead to the charge of count 1, conspiracy to commit a burglary, second degree?
Guilty.
How do you plead to count 2, conspiracy to commit a burglary in second degree?
Guilty.
Count 3, burglary in the second degree, how do you plead?
Guilty.
Count 4, burglary in the second degree, how do you plead?
Guilty.
Theft by taking, count 5, how do you plead?
Can I talk with my attorney?
Yes, at any point. Mhm.
We're ready to proceed.
Okay. How do you plead to the count 5, theft by taking?
Guilty.
How do you plead to count 6, possession of tools for commission of a crime?
Guilty.
How do you plead to count 8, theft by taking, misdemeanor?
Guilty.
And how do you plead to count 9, giving false name and birth date to law enforcement officers?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing what is called a habeas corpus petition?
Yes.
Do you understand that for a felony charge, you have only 4 years from today's date to file that petition?
Yes.
Do you understand that for a misdemeanor charge, you only have 12 months from today's date to file that petition?
Yes.
At this time, the state will provide a factual basis for the felony plea in this case. The state will, as the facts are pretty long, the state is going to try to provide a condensed version of the facts. If this matter had went to trial, the state would have been able to prove beyond a reasonable doubt that on the incident date of January 10th, 2022, at the incident location of 2033 Monroe Drive Northeast, Fulton County, officers responded to a prowler call at the storage facility of Extra Space Storage located at 2033 Monroe Road Northeast. The complaint or the response call indicated that there were 4 Black males attempting to break into a storage unit. 2 were inside the facility and 2 were sitting in a blue SUV behind the building. Arriving first on scene with the unit, Officer Marsh observed a parked blue Toyota RAV4 with the Georgia tag license plate C as in Charlie, J as in jar, L as in Larry, 3575, occupied by a driver, Darius Turner, date of birth 9/1996, and passenger Deshae Gibson, date of birth 1/7/1995. The vehicle was confirmed stolen on today's date out of Cobb County. Cobb County PD case number 22002052. As both occupants were being ordered out of the vehicle, officers observed a small plastic bag being tossed under the vehicle. Both occupants were detained, and upon identifying themselves, Mr. Deshae Gibson first provided an ID belonging to a Mr. Brandon Williams with the date of birth 7/27/1992. His real ID was found in his wallet along with a Georgia license belonging to Mr. Armand Randall, date of birth 8/29/1985. Units 3211 and Unit 3212, both storage units, officers responded to the scene and began clearing the storage facility. Officers responded as well, and moments later, they observed 2 males matching the lookout given by the 911 caller walk away from the building, leaving behind a cart with several suitcases and bags. The 2 males were detained and identified as defendant Kenneth Millen and defendant Royce Bell. Upon inventory of the vehicle, officers recovered a burnt glass pipe associated with smoking narcotics under the passenger seat. They also located several tools which were associated with the way of entry into the storage units, and they recovered plastic baggies with drugs and methamphetamine. The vehicle was recovered. The defendants were arrested and transported to Fulton County Jail. The state will provide this court an overview of the defendant's criminal history. The defendant has a total of 12 cycles of arrest. And he has no felony convictions. Nothing further from the state.
All right, Ms. Roberts.
Yes, accept the plea as negotiated with the state. Since I've been speaking with Mr. Gibson, he has let me know how serious it is for him to get help with these drug issues. I believe it has been a long time coming for him with his history, and then culminating with this charge was one of the things that in our plea negotiations that are discussed with ADA Clark was that it encompassed something, some drug treatment. And so he is willing to accept responsibility for what happened. He is here willing to try to make amends and is asking the court to accept the plea, allow him to go on probation and do the things that he needs to do to become a productive member of society. He is a very smart young man. Obviously, with his medical condition, he has a lot on his plate to deal with, but I do believe that given the opportunity, he can be a productive member of society. And so we would ask that the court would accept the plea as negotiated.
Okay, Mr. Gibson, do you understand the nature of the charges against you?
Yes, sir.
You've just heard from ADA Clark explain all the rights you give up by this guilty plea. So your wish to give up these rights and have this court accept your plea of guilty.
Yes, sir.
You understand that the court is not bound by the recommendation of the plea agreement, and I can sentence you as I deem appropriate.
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
Ms. Roberts, are you satisfied that your client is competent in understanding that the plea is voluntary and there's sufficient factual basis for entering the plea?
Yes, sir, we do.
I find there's a sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. I will accept your guilty plea and sentence you to the recommended sentence, which is as follows. Count 1, 2 years confinement, commuted time served, plus the special conditions of the plea. Count 2, 2 years confinement, commuted time served, to be served concurrently. Count 3 is 5 years, 2 years confinement, commuted time served, also concurrent. Count 4, 5 years, 2 years confinement, commuted time served, also concurrent. Count 5, 1 year confinement, commuted time served, also concurrent. Count 6, 1 year confinement, commuted time served, concurrent as well. Count 8, 12 months of confinement, concurrent. And count 9, 12 months of confinement to run concurrent. Here's the special conditions. Mr. Gibson is to have no contact with any of the victims in this case, and he must remain at least 200 yards from them at all times. He's prohibited from contacting any victim on social media or through any other third party. Victims in this case are Daryl Marvin, June Rogers, and Samantha Adams. Defendant is required to stay away from the incident locations of 23-3 Monroe Drive. Defendant must have no contact with any of the co-defendants in this case. They are Kenneth Millen, Royce Bell, and Darius Turner. Mr. Gibson must be evaluated for drug and alcohol abuse within 60 days of his release from confinement and must follow any recommended treatment. Defendant must wear an ankle monitor for the first 2 years of his probated sentence upon release from Fulton County, and the county will pay, the ankle monitor will be paid for by the state. First 2 years of defendant's probated sentence, he's subject to a curfew of 8 p.m. to 8 a.m. and is only allowed to attend the following: work, school, religious faith services, lawyer, medical appointments during the day and or during the curfew period. Your work schedule must be provided to your probation officer. You must attend weekly NA meetings for 18 months after you're released for custody and must provide the proof of attendance to your probation officer. No drugs or alcohol unless prescribed by a doctor. You'll be subject to random drug screenings, and you must be gainfully employed within 60 days of first reporting to the probation. And you must remain employed the entire time you're on probation. Gainful employment is defined as working at least 40 hours per week or attending a vocational trade or work program full-time while you're on probation. And you're to provide proof of your employment to your probation officer. Anything else?
That is all, Your Honor.
Ms. Clark?
No, Your Honor.
Okay, Mr. Gibson. You've got a lot of special conditions on your probation. I hope you follow them. Your attorney said you're a bright young man. I hope that you're able to complete these programs that are designed to help you deal with your addictions. And I hope that, you're able to find gainfully employed or a vocation or something else that can lead you on the right path.
Thank you, Your Honor.
Okay, you're excused.
Your Honor, that's all the business I have before the court. May I be excused?
Your excuse.
Thank you, sir.
Who we doing next? Millen.
Your Honor, I need to get my power cord.
Yeah, go ahead. It's a power cord kind of day. What? I know, well. But I knew, you know what, I absolutely knew you were gonna do that. So ridiculous. So predictable. You're more predictable than I am. How are you? Yeah. What about Mr. What about Julian? Doesn't he have an announcement? Yeah, why don't we do his announcement? See, I'm looking out for you still, even after you abandoned me. Which case is, which number, which one is this, Mr. George? Duval?
I'm here, Judge, whenever you're ready to. I'm sorry, I couldn't get off mute.
Yeah, we've got just a brief announcement. I think it's brief, right? Okay, go ahead.
Your Honor, we have extended a final plea offer in that case. I have been made aware, still that there is a second pending case currently that Mr. Duval has open. Case number.
Yeah, why don't you give it to me?
Your Honor, it is 23 SC 188-797. That has already been arranged at Judge Cox's courtroom. And that's Ms. Hill discovery this morning, just as far as that case. Your Honor,
It's coming my way, right?
yes, Your Honor. At this point, at this juncture, I would be willing to extend the same offer this case, which is 2017 roughly, and extend that as a global.
All right, Ms. Hill.
Yes, Ron, you and I just got discovered for that case.
Okay. We will do this October 23rd then, and trial calendar shortly thereafter. Okay, you're excused, and you're excused as well, Ms. Hill.
Let me ask you a question about Mr. Lance Anderson, who's, I'm not sure, but.
It was 6 and 7.
6 and 7.
Okay. So Sanderson was on the consolidated count. Is that what you're talking about?
He was on the calendar as position 6 and 7 today, Your Honor. When I looked him up at ICD, already had it for the second.
Yeah. What happened was he had on our consolidated calendar. Savings for like a month or so. And so they did not, do this, so I took him off and put him on.
And so he's going to be ready on October, the honeymoon. His honeymoon's over.
I know he has a similar name to another attorney, but I believe I saw him last week. I believe that Mr. Sanders is going to be a global plea. Deputy McCauley did send me an email, pretty much disposed to negotiate a plea.
All right.
So we'll be able to take that out.
Okay.
Thank you. May I be excused?
Yeah, you're excused.
Good to see you all.
Good to see you. All right, so we won't be putting him on the next consolidated. We'll go over that consolidated. All right. Back to business. So you have the paperwork? Who has the paperwork on this? No, I already did Gibson.
Or Millen.
This is Millen, yeah. So let's go to Millen. All right, so Ms. Bumpus, you're on Zoom? Ms. Bumpus?
Yes, I'm here, Judge.
Okay, this is 22 SC 184195. Kenneth Wayne Millen Jr., that's you?
Yes, sir.
Okay, he's present in the courtroom. His attorney, Miss Kayla Bumpus, is appearing by Zoom. His attorney, Miss Bumpus, is appearing by Zoom. And we have Miss Christina Clark from the district attorney's office is present in the courtroom as well. So wait a minute, we're tracking down. So what do you have here? So this is the waiver. Okay, let me go over this real quickly here. Well, first of all, Mr. Millen, your attorney, Miss Bumpus, is on by Zoom. And so if you have any questions, concerns, or thoughts about, you're going to be asked a bunch of questions. And we're going to tell you a lot of things. And so if you have any questions, concerns, or comments that you need to discuss with your attorney, you let me know and we'll stop this proceeding and arrange for you to be able to speak with Ms. Bumpus privately, okay?
Yes, sir.
Do I have your permission to go forward with this with her on Zoom?
Yes, sir.
All right, so let me go over this paperwork here very quickly. So we have Miller, Bumpus. So this is your, can you just, Deputy, can you do me a favor? Can you just confirm that this is Mr. Millen that signed that right there? Just him, just.
You
signed that? Okay.
Okay. So Mr. Millen, just for confirmation, you pointed to it, but you did sign under the guilty portion of this indictment, you signed your name, correct?
Yes, sir.
Okay. And so we have, so now Ms. Bumpus, you signed this paperwork before you left earlier?
Yes, I did.
Okay. And you've gone over the indictment and then the waiver of rights with your client? You've gone over all that with him?
Line by line.
Okay, and it looks like I need you to sign the indictment, Ms. Clark. Here you go.
Okay.
Okay, and so Ms. Clark, you have a negotiated plea to present?
Yes, Your Honor.
All right, go ahead.
Defendant Millen, is that how you pronounce your name?
Yes, ma'am.
Okay. Please raise your right hand. Do you swear or affirm that any evidence or testimony that you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
You can put your hand down, sir. Please state and spell your true, correct, and legal name.
Kenneth Millen Wayne Jr., KENNETH WAYNEMILLEN JR.
Are you at this time taking or under the influence of any alcohol, drugs, or medication?
No, ma'am.
Is there a medication that you normally take that you have not taken or been given today?
No, ma'am.
How old are you?
40.
What's the highest level of education or the last grade you completed?
9.
Where did you go to high school?
Douglas.
Are you able to read, write, and understand the English language?
Yeah, ma'am.
I didn't hear you.
Yeah, ma'am.
Do you understand that you've been charged with the following offenses?
Yeah, ma'am.
I will read those out to you. Count 1, conspiracy to commit a burglary in the second degree. Count 2, conspiracy to commit a burglary in the second degree. Count 3, burglary in the second degree. Count 4, burglary in the second degree. Count 5, theft by taking. Count 6, possession of tools for commission of a crime. Count 8, theft by taking. Do you understand that you've been charged with those offenses?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yeah, ma'am.
At any given point, you're on, your attorney is on Zoom, but if there's something that I ask you, because my job as prosecutor is to make sure that your rights are preserved as well. So if there's something that I ask you that you do not understand and you need to talk with your attorney, then the court will make provisions for you to speak with your attorney privately, okay?
Yeah, ma'am.
All right. Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yeah, ma'am.
Do you understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yeah, ma'am.
Have you had an opportunity to review the waiver of rights form and the indictment with your attorney?
Yeah, ma'am.
And did you understand the waiver of rights form as explained to you by your attorney, Ms. Kayla Bompus?
Yeah, ma'am.
And did you understand the indictment as explained to you by your attorney?
Yeah, ma'am.
And is it your decision to waive your rights today?
Yeah, ma'am.
And did you sign the waiver of rights form?
Yeah, ma'am.
And did you sign the indictment with your attorney that has the guilty plea on it?
Ma'am.
Your Honor, at this time, the state moves to enter the waiver of rights form and the indictment into the record.
So moved.
Have you had enough time to speak with your attorney about all of the charges in the indictment against you, including the facts and circumstances relating to these charges?
Yeah, ma'am.
Would you like more time to discuss the case with your attorney, Ms. Kayla Bompus?
No, ma'am.
I didn't hear you.
No, ma'am.
You said no, ma'am. You don't, okay. Are you satisfied with your attorney's services?
Yeah, ma'am.
Attorney Bumpus, do you waive a formal reading of the indictment for purposes of this plea?
So waive for purposes of this plea.
Do you waive any and all defects in the indictment for purposes of this plea?
So waive for purposes of this plea.
Your Honor, the state is unaware of any outstanding warrants related to the charges within this indictment. Defendant Millen, do you remember having been arrested on these charges?
Yeah, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yeah, ma'am.
The state will provide those for the record. For count 1, conspiracy to commit a burglary in the second degree, the sentence is, can be no more than half the time of the actual felony that has been committed. Burglary in the second degree carries a sentence of between 1 and 5 years, which means the state would be prohibited from recommending any sentence that is more than 2.5 years on the conspiracy to commit a burglary charge. For count 2, conspiracy to commit burglary, same charge, no more than 2.5 years. For count 3, burglary in the second degree, it is minimum is 1 year in prison. The max is 5 years in prison. For count 4, burglary in the second degree, the minimum is 1 year. The maximum is 5 years in prison. For theft by taking, based on the amount that was taken, the minimum is 1 year. The maximum is 5 years in prison. For possession of tools for commission of a crime, the minimum is 1 year. the maximum is 3 years. For count 8, theft by taking misdemeanor, the minimum is 1 day in jail, the max is 12 months in jail. Is that your understanding?
Yes, ma'am.
Do you understand that you're entering a negotiated plea of guilty, which means that the state and the defense jointly will recommend the following sentence to the court?
Yes, ma'am.
For count 1, the state's recommendation for conspiracy to commit a felony is 2 years confinement commuted to time served. For count 2, conspiracy to commit a felony, which is burglary in the second degree, the state's recommendation is 2 years confinement commuted to time served, balanced to run concurrent.
Wait a minute, you said count 2 is the burglary in second degree?
Yeah, I intended on your honor to say that count 1 was conspiracy to commit burglary in the second degree. It's the same felony. I just didn't say it on the first one.
Okay.
Okay, so count 1, conspiracy to commit burglary in the second degree. The state's recommendation is 2 years confinement commuted to time served, plus count 2, conspiracy to commit burglary in the second degree. The state's recommendation is 2 years confinement. Count 3, burglary in the second degree. State's recommendation is 5 years, 2 years confinement commuted to time served. This sentence runs concurrent with count 1, plus the special conditions of probation as listed below. Count 4, burglary in the second degree. State's recommendation is 5 years, 2 years confinement commuted to time served. Sentence runs concurrent with count 1, special conditions of probation as listed below. Count 5 is theft by taking, 1 year confinement commuted to time served. Sentence runs concurrent with count 1. Count 6 is possession of tools for commission of a crime. Sentence recommendation is 1 year confinement commuted to time served. Count 8 is theft by taking, misdemeanor, 12 months confinement, sentence to run concurrently with count 1. Oh, and for, and the special conditions of probation, defendant has a no contact order with the victims in this case. He must remain 200 yards away. The victims in this case are Daryl Marvin, June Rogers, and Samantha Adams. Defendant is required to stay away from the incident location of 2033 Monroe Drive Northeast. Defendant must have no contact with his co-defendants from this case, which are Deshae Gibson, Royce Bell, and Darius Turner. Defendant must be evaluated for drug and alcohol abuse issues within 60 days of his release from confinement. He must complete treatment if deemed necessary. Defendant must wear an ankle monitor for the first 2 years of his probated sentence. Upon his release from Fulton County, the ankle monitor will be paid for by the state. For the first 2 years of defendant's probated sentence, he's subject to a curfew of 8 p.m. to 8 a.m. and he is only allowed to attend the following: work, school, religious faith services or meetings with his lawyer, medical appointments during the day and or during the curfew period. Work schedule must be provided to his probation officer. Defendant must attend weekly NA meetings for 18 months after he's released from custody, and he must provide proof of attendance to his probation officer. No drugs unless prescribed. Defendant shall be subject to random drug screens. Defendant must be gainfully employed within 60 days of his first day of reporting to probation, and he must remain employed the entire time he's on probation. Gainful employment is 40 hours per week. The state has provided a email with the terms of this plea offer to the court as well as to the court reporter. Is that your understanding, Defendant Millen, of the terms of the plea?
Yeah, ma'am.
Do you understand that the court is not required to accept the state's recommended sentence?
Yeah, ma'am.
Do you understand that the court has the right to sentence you to the maximum possible sentence on each charge?
Yeah, ma'am.
Do you understand that as there are multiple charges to which you're pleading guilty today, the court is also has the right to run those sentences or counts consecutively, meaning one after the other?
Yeah, ma'am.
Do you understand that if the court decides to order a sentence that differs from the negotiated plea you were expecting today, that you do have the right to withdraw your plea of guilty?
Yeah, ma'am.
Are you currently on probation or parole?
No, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today.
Yeah, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit, whether municipal, county, state, or federal?
Yeah, ma'am.
Do you understand that if you are on probation, you must follow all the special conditions of your probation?
Yeah, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yeah, ma'am.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yeah, ma'am.
Are you a United States citizen?
Yeah, ma'am.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yeah, ma'am.
Do you understand that doing so will result in new criminal charges for which you face a sentence of between 1 and 10 years?
Yeah, ma'am.
Do you understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yeah, ma'am.
Do you understand that if you were in the future to use a firearm in the commission of a crime, you would face up to a 15-year custodial sentence consecutive to this sentence for the underlying felony?
Yeah, ma'am.
Do you understand that by entering this felony plea, you will be a convicted felon?
Yeah, ma'am.
You understand that even after you are off probation, you can never, ever have a gun in your possession?
Yeah, ma'am.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yeah, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena any witnesses on your own behalf, the right to testify against yourself or offer other evidence. You're giving up the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial. Is it your decision to waive these rights, which means not to use them, and to enter a guilty plea today?
Yeah, ma'am.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yeah, ma'am.
As to indictment number 22 SC 184195, how do you plead to count 1, conspiracy to commit a burglary in the second degree?
Guilty.
How do you plead to count 2, conspiracy to commit a burglary in the second degree?
Guilty.
How do you plead to count 3, burglary in the second degree?
Guilty.
Count 4, burglary in the second degree.
Guilty.
Count 5, theft by taking.
Guilty.
Count 6, possession of tools for commission of a crime.
Guilty.
Count 8, theft by taking, misdemeanor.
Guilty.
That's all of them. Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yeah, ma'am.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yeah, ma'am.
I didn't hear you.
Yeah, ma'am.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yeah, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing what is called a habeas corpus petition?
Yeah, ma'am.
Do you understand that for a felony charge, you have only 4 years from today's date to file that habeas corpus petition?
Yeah, ma'am.
Do you understand that for a misdemeanor charge, you have only 12 months from today's date to file that petition?
Yeah, ma'am.
At this time, the state will provide a factual basis for the felony plea in this case. If this matter would have went to trial, the state would have been able to prove beyond a reasonable doubt that on January 10, 2022, APD officers responded to a prowler call at the extra space storage located at the incident location of 2033 Monroe Road Northeast, Fulton County, which the caller alerted that 4 black males were attempting to break into storage units. 2 were inside the facility and 2 were sitting in a blue SUV behind the building. Arriving first on scene with unit 3208, officers observed a parked blue Toyota RAV4 with Georgia tag CJL 3575, occupied by a driver, defendant Darius Turner, and passenger Deshae Gibson, defendant. The vehicle was confirmed stolen on today's date out of Cobb County. As both occupants were being ordered out of the vehicle, officers observed a small plastic bag being tossed under the vehicle. Both occupants were detained, and upon identifying themselves, defendant Deshae Gibson first provided an ID belonging to a Mr. Brandon Williams. His real ID was found in his wallet with a Georgia license plate along by the name of Mr. Armand Randall. Additional patrol units responded to the scene and began clearing the storage facility. Unit 3294 responded as well, and moments later observed two males matching the lookout given by the 911 caller walk away from the building, leaving behind a cart with several suitcases and bags. The two males were detained and identified as the defendant in this case, Kenneth Millen, with the date of birth of 6/3/1983, and Royce Bell, date of birth 1/22/1983. Officers took an inventory of the items recovered from the vehicle. They recovered items such as a glass pipe and several tools that are associated with tools that would allow entry into storage units. The defendants were arrested and booked and processed in Fulton County Jail. The defendant's criminal history. Per the GCIC, the defendant has 14 arrest cycles. And he has a 2012 conviction for felony obstruction. One moment, Your Honor.
Okay.
All right, Your Honor, pursuant to a GCIC, the defendant has a total of 14 cycles of arrest. He has a probation violation conviction from 2001 in Troop County. A theft by receiving felony conviction from 2006 in Troop County. Nothing further from the state, Your Honor.
Okay, Ms. Bumpus,
Yes, Judge.
do you have anything you'd like to add?
No, I just ask that you accept this plea as negotiated between the state and I. My client's been in custody over 500 days.
Okay. Mr. Millen, do you understand the nature of the charges against you?
Yes, sir.
You've just heard from ADA Clark explain all the rights you give up by this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes, sir.
You understand the court is not bound by the recommendation or the plea agreement. I could sentence you as I deem appropriate.
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
Ms. Bumpus, are you satisfied that your client's competent in understanding the plea is voluntary and there's sufficient factual basis for entering the plea?
Yes, Your Honor.
Okay, I find that there's sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. I will accept your guilty plea and sentence you as follows. If you could put yourself on mute, Ms. Bumpus, thank you. Getting a little feedback there. And I'm going to sentence you to the recommended sentence. That's count 1, 2 years confinement commuted to time served. Count 2, 2 years confinement commuted to time served. Count 3, 5 years, 2 years confinement commuted to time served. Count 4, 5 years, 2 years confinement commuted to time served. Count 5, 1 year confinement commuted to time served. Count 6, 1 year confinement commuted to time served. And count 8, 12 months confinement commuted to time served. All these counts are to run concurrently. And the special conditions of probation are that the defendant have no contact with any of the victims in this case. You must remain at least 200 yards away from them at all times. You're prohibited from contacting any victim on social media or any other third party. The victims in this case are Daryl Marvin, June Rogers, and Samantha Adams. You're required to stay away from the incident location. You must have no contact with your co-defendants in this case. And your co-defendants are Deshae Gibson, Royce Bell, and Darius Turner. You must be evaluated for drug and alcohol abuse issues within 60 days of release from confinement, and you are to follow any recommended treatment and remain in compliance with that. You are to wear an ankle monitor with the first 2 years of your probated sentence upon release from Fulton County. Ankle monitor to be paid for by the state. You are going to have a curfew during your probation of 8 p.m. or for the first 2 years of your probated sentence from 8 p.m. to 8 a.m. And you'll only be allowed to attend the following: work, school, religious faith services, meetings, lawyers, and medical appointments during the day and or during the curfew appointment. Your work schedule must be provided to your probation officer. You must attend weekly NA meetings for 18 months after your release from custody, and you must provide proof of attendance to your probation officer. No drugs or alcohol unless prescribed by a doctor. You shall be subject to random drug screenings, and you are to be gainfully employed within 60 days of first reporting to probation. You are to remain gainfully employed the entire time you're on probation. Gainful employment is defined as 40 hours per week or attending a vocational trade or work program full-time while you're on probation. You shall provide evidence of your employment to your probation officer. And I believe that's it. Is that it?
That is it, Your Honor, from the state.
That is it from defense as well.
Oh, the ankle monitor is to be paid for by the county. Thank you. Anything else? All right, you're excused, Mr. Millen.
Your Honor, that concludes my business. May I be excused?
You are excused, Ms. Bumpus.
Good.
All right, we'll take a break. Quick one. What? What's the next one? How many more do we have? This is it. All right, tell Maxie I got one more. Yeah. Yeah, I mean, were you able to find anybody in your office any of those 3 days? Yeah.
There were a couple people in court, but as of now, it was like. We're talking about.
What's Corey Marshall? Let me look up Corey Marshall here. Mr.
Yeah.
Oh, rape. All right.
Eric Parks.
Mr. Clark.
I mean, if it's just based on reports.
All right, I'll tell you what, and let's keep it on the calendar, and we'll have to do it right before the trial. If I did, as a side note, I spoke with the judge on the Pitts case, which I believe Fawcett said he was ready to go to trial on that. He did, and she feels pretty good that that's going to be resolved, and she'll know by Wednesday at noon. So I'll, yeah. I called her. Keep Pitts on for sure. That's my A1. I mean, is there a reason not to have him on there? Okay. Yeah.
Judge, and this is just kind of, I guess. Would it be possible to have on Monday to start Tuesday?
How long do you think it's going to be? Because Mr. Clark, we've heard about Mr. Clark's vacation a few times today, so.
We're done by Friday, which I can't imagine.
I mean, unless the jury takes twice the time to trial.
But it's not being, yeah, I mean, would it need to, they got to deliberate too, so.
If it's a proffer, anybody can do it, right? If it's a proffer, I can do it.
Talk to her if you can. I mean, it'd just be helpful to be able. I know, but let's see if we can get it done this week. Only because it just, I know how these things go. Everybody's optimistic that they can get through it. And then all of a sudden,
I mean, I think, I'll speak with.
talk with Kathy. It would be nice to do it Wednesday, Thursday. or Friday. Y'all the three of y'all get together and see if you can do it. I'd like to be able to, and then I can, because I can take a look at it all. Both of y'all can digest whatever my decision is and just be a little more prepared as you go into the trial. So, okay. All right.
I'll keep the court updated.
Thank you. You're excused.
And then I guess we'll know on Thursday anyway, if it's cases.
Well, but I mean, I can't, just because they say it's gonna go, but I
I understand, yeah.
we'll know if there's like a 90% chance if it's gonna go. I will let y'all be the second to know behind me. So.
Thank you.
Thank
All right.
Judge.
So is that the case that's going up for next week, Your Honor?
Yeah, I've got Parks. What, pardon me?
Pitts is going next week?
Well, no. The conflict was with Judge Kraus and, I talked with her, right? They feel like there's a pretty good chance it'll settle. If it does, I will know Wednesday by noon.
Okay.
So. Yeah, that was Marshall. Yeah, I'd like to do it.
The 413, right?
Yeah.
Yeah, I mean, I've done plenty of that.
That's way to step up.
I tried, Judge. I tried. Look, I tried.
Marsh, Ms. Precious, ask Ms. Mack. I used to be in SAU, so I don't think she'll have any issue, but ask her. I can do it on Thursday. Okay, yes.
Yeah, that is one plea left.
Yep. Oh, okay. Well, Miss Tanya Jones, are you talking about Harvey Jamal? Oh,
Schlocker. All right. Which one's Schlocker? Oh, Shalaka Young. Okay. I thought there was some guy named Schlocker. I was like, we didn't talk about Schlocker today.
If we could, yeah.
All right, let's bring out Young because Jones is still with her, right?
I have a question.
All right, well, can we bring out Young for, well, wait, you got your client. All right. Sorry, Mr. Clark.
No.
Okay. This is 22 SC 185-263. Eric Tyrone Parks Jr., who's present in the courtroom with his attorney, Ms. Jones, and we have Ms. Iqbal with the state. Ms. Iqbal, you have a negotiated plea to present?
Yes, Judge.
Go ahead.
Okay, sir, please raise your right hand. Do you swear or affirm that any evidence or testimony you shall give in the matter currently pending before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can lower your hand. Please state, spell your true, correct, and legal name.
Eric Parks, ERICPARKS.
And are you a junior?
Yes,
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
no, ma'am.
Is there a medication you normally take that you have not been given today?
No, ma'am.
How old are you?
26,
And what's the highest level of education you've completed?
college.
And did you complete college?
Yes,
Are you able to read, write, and understand the English language?
yes,
And do you understand that you've been charged with the following offenses? 1 count of aggravated battery, 1 count of aggravated assault, 1 count of false imprisonment, 3 counts of cruelty to children in the 3rd degree, and then 1 count of obstructing or hindering a person making an emergency telephone call. Do you understand that, sir?
yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, then the state is required to prove the charges against you at a jury trial?
Yes, ma'am.
Have you had an opportunity to review the waiver of rights form with your attorney?
Yes, ma'am.
Did you sign the waiver of rights form?
That's the sheet outside. Yes, ma'am.
And then did you have an opportunity to review the indictment with your attorney?
Yes, ma'am.
And did you sign the indictment?
Yes, ma'am.
Your Honor, at this time, state moves to tender in both the waiver of rights form and the indictment form into the record.
So moved.
And sir, have you had enough time to speak with your lawyer about all the charges in this indictment against you, including all the facts and circumstances related to these charges?
Yes, ma'am.
Would you like any more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, do you waive formal reading of the indictment?
We do.
And do you waive any and all defects in the indictment, including any with respect to his name?
We do.
Sir, has your attorney advised you of the minimum maximum sentence for each charge that you're pleading here today?
Yes, ma'am.
You understand aggravated battery and aggravated assault have the same minimum 1 year, maximum 20 years. False imprisonment, the minimum is 1 year, the maximum is 10. Cruelty to children in the 3rd degree is a misdemeanor, so the minimum is 1 day, maximum is 12 months. And then obstructing or hindering a person making a emergency call, that's also a misdemeanor, so it'll be minimum 1 day, maximum 12 months. Do you understand that, sir?
Yes, ma'am.
Do you understand today you're entering a negotiated plea of guilty, which means that the state and the defense will jointly recommend the following sentence to the court? For count 1, it's 7 years to serve 18 months, balance on probation. Special conditions of probation: must complete a family violence intervention program within 12 months after his release. Must also pay restitution of $1,800 and have no contact with the victim. Count 2, Your Honor, will be 7 years to serve 18 months, balance probated to run concurrent to count 1. Count 3, false imprisonment, 7 years to serve 18 months to run concurrent to count 1. Cruelty to children, all 3 of those, Your Honor, would be 12 months to serve to run concurrent to count 1. And also obstructing a hindering person making a telephone call would be 12 months to serve to run concurrent to count 1.
And what was count 1 again?
Aggravated battery.
No, but what was the sentence on that one?
Oh, 7 years to serve 18 months.
Okay.
Balance probated, the special conditions of restitution of $1,800 and must complete a family violence intervention program.
Okay.
And sir, do you understand that's what the state is recommending to the court?
Yes, ma'am.
And do you understand that the court is not required to accept the state's recommendation? You understand that the court has a right to sentence you to the maximum possible sentence on each charge and run those consecutively, meaning one after another. Do you understand that?
Yes, ma'am.
Are you currently on probation or parole?
No, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes, ma'am.
Do you understand that if you're on probation, you must follow all the special conditions of your probation? Do you understand that?
Yes, ma'am.
Do you understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence? Do you understand that?
Yes, ma'am.
And do you understand that you're not allowed to possess or use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Okay. Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes, ma'am.
Do you understand doing so will result in new criminal charges for which you could face a sentence between 1 to 10 years?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you may not use a firearm in a crime in the future?
Yes, ma'am.
Do you understand that if you were to use a firearm in the commission of a crime in the future, you could face up to a 15-year custodial sentence consecutive to the sentence for the underlying felony?
Okay.
And are you being asked to be treated under first offender?
Yes, ma'am.
Okay. So you're being asked to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am.
And have you ever pled guilty or nolo contendere to a felony in the state of Georgia?
No, ma'am.
Have you ever pled guilty to a felony in any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, whether felony or misdemeanor, under the First Offender Act?
No, ma'am.
Has your lawyer explained the First Offender Act to you?
Yes, ma'am.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, which means you could be resentenced and adjudicated guilty, and you could be resentenced to the maximum, which is sentences on each of the charges. Do you understand that?
Yes, ma'am.
Do you understand that by pleading guilty to a do you understand that by pleading guilty today, you are waiving any and all defenses, including any mental health defenses?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to trial by jury, the right to remain silent, the right to confront witnesses against you, the right to subpoena any witnesses on your behalf, the right to testify against yourself or offer other evidence, the right to the assistance of counsel, the right to the presumption of innocence, the right not to incriminate yourself, and the right to appeal if convicted of these charges at a trial? Do you understand that, sir?
Yes, ma'am.
Is it your decision to waive these rights and enter a guilty plea today?
Yes, ma'am.
Has anyone forced, threatened, coerced, or promised you anything to get you to enter this guilty plea?
No, ma'am.
Is it your decision to enter a guilty plea because you're in fact guilty?
Could you say that again?
Is it your decision to enter a guilty plea because you are in fact guilty?
No, ma'am.
You're not guilty?
Yes, ma'am. Yes, ma'am. I'm sorry. I'm
She's
sorry.
asking if you're guilty or not.
Oh, okay, okay. My bad. I'm sorry.
Okay.
Yes.
Okay, so as to indictment number 22 SC 185263, how do you plead to the charges of 1 count of aggravated battery, 1 count of aggravated assault, 1 count of false imprisonment, 3 counts of cruelty to children in the 3rd degree, and 1 count of obstructing and hindering a person making an emergency telephone call? How do you plead?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that if you wish to file a direct appeal, you must do so within 30 days from today's date?
Yes, ma'am.
Do you understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition, and you only have 4 years from today's date for the felony charges to file that petition, and you have 12 months from today's date for the misdemeanor charges to file that petition? Do you understand that, sir?
Yes, ma'am.
Okay. Your Honor, had this case gone to trial, the state would be able to prove beyond a reasonable doubt that on February 26th, 2022, officers responded to 4590 Washington Road, apartment T1, which is located in Fulton County. And it was a reference to a suspicious call. And basically at this point, Your Honor, the victim, her name is Chelsea Jackson. She posted a help call on Instagram and a picture of her battered face. And then that's when a friend reported and called the police for her. When officers arrived at that location, they spoke with the victim, Ms. Jackson, who reported that her boyfriend had assaulted her over the night, that previous night, and had held her hostage inside the apartment. They were arguing because she thought he was having, because the defendant believed the victim was having an affair. The argument escalated. That's where the defendant, he punched her multiple times with a closed fist. He put his hands around her neck, strangling her as well. Her three children were also present at the time of this incident. And so she did grab, during the fight, at one time, she grabbed a hammer, she threw it at him, it left a hole in the wall. And then the defendant grabbed her and threw her against the wall. She attempted to call 911, but he took her cell phone and hid it from her. And so the next day she tried to leave to tell him, that she was going to go to work. And what she was able to do was he wouldn't let her leave because of her battered face and her bruised face. So what she ended up doing is using her child's tablet to log on to Instagram, and was taken to Grady. Grady arrived on scene, but she refused treatment due to concern for her children. But she did get checked by paramedics. She had a swollen upper lip and multiple lacerations on her head and neck. And she was speaking very raspily due to being strangled. This defendant has no felony convictions whatsoever, Your Honor. I spoke with the victim. She's okay with this. Her biggest thing is that she wants him nowhere near her and that he pay the restitution for money that he stole that day.
So is there, maybe I didn't catch it. So there's a no contact?
Yes, of course, no contact with the Chelsea Jackson.
Okay.
I didn't name her when during the litany. I just said no contact with the victim.
All right, well, that's my mistake for not writing that down. Ms. Jones?
Thank you, Your Honor. As my client indicated, he's 25 years old. This is the first time he's been arrested for a felony, as far as I can tell. Prior to his arrest, he was working at UPS as a package handler, as well as doing audio engineering, which is what he has his degree in, Your Honor. His father is here in support of him today. We've been working pretty hard at a resolution in this particular case, and I think it is a fair resolution. My client is remorseful for losing his temper. He has always fully admitted to me that while not everything in the factual basis is probably true, that there was definitely a fight. There was definitely a fight over her potential infidelity, and he took anger management classes while in jail and some other classes to try to improve himself as he awaited his court date, Your Honor. I think that Mr. Parks is a good candidate for probation. I don't think we'll see him again. He's going to try to pay off that $1,800 restitution as quickly as possible and start taking those Family Violence Intervention Act classes, Your Honor. So we just respectfully request that you follow the recommendation and give him first offender.
And Judge, one more reason for this recommendation also I took into account was that the victim's child's father shot him the next day. In retaliation after he found out what happened.
Yeah. So if I approve this, he's still got a little time left to do that, right?
It should be 180 days roughly now, Your Honor.
Okay.
And another consideration is his grandmother, who's cared for him all of his life, is currently in hospice care. And he would like to be out there to spend the last final moments with her. And because he's done real well in the jail, taken all the classes he needs to take, no write-ups, the state was agreeing to the 18 months.
Okay. And what's the restitution for?
So there was, she basically ended up getting evicted because there was a money order that he ended up stealing, that he ended up taking. And so she wants
Okay.
the money back.
When can he have the restitution done? I'd like to put a date on it. Doesn't need to be overly aggressive, but I just want something before his probation's finished that,
Your Honor, we can agree to $100 per month, and if he can pay more, then he can do that. My understanding is they're going to try to pool some family resources to get that paid off sooner rather than later, Your Honor. But I don't want to set my client up for failure either.
I agree with that. So $100 per month minimum. You good with that?
Yes, sir.
And what about when can he have that family violence intervention?
I think we can
class
do
done?
that within a year of release, Your
Okay,
Honor.
12 months, all right. Okay, Mr. Parks, do you understand the nature of the charges against you?
Yes, sir.
I see his father's raising his hand in the back here. You have just heard District Attorney Iqbal explain all the rights you give up by entering this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes, sir.
You understand the court is not bound by the recommendation of the plea agreement, and I can sentence you as I deem appropriate.
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
Ms. Jones, you satisfied that your client is competent, understand the plea is voluntary and that there is sufficient factual basis for entering the plea?
I do.
All right, before we go down the road of the first offender, and I know you were asking questions on it, just want to make sure when you understand it's first offender, it's a once in a lifetime opportunity, right?
Yes, sir.
And you understand the pros and the cons. If I approve this, you're going to have 7 years probation. Well, it's not actually not the probation. It's you could be sentenced to a very hefty sentence. We can come back in and resentence you on all of these charges that you're pleading guilty to. Do you understand that?
Yes, sir.
If you don't comply with the terms of your probation. The good news is if you do, you essentially don't have a record. When you're applying for a job, you don't have to list that you've been convicted of a felony. And so it can be very positive, assuming that you have, you're going to have to be very careful while you're on probation. You understand all that?
Yes, sir.
Okay. The court finds that you, Mr. Parks, understand the nature of the crimes and the consequence of this plea. There is a factual basis for the plea. The defendant has knowingly, intelligently, voluntarily entered this plea. The defendant has requested a sentence under the First Offender Act. The court will approve that request, withhold adjudication, and is hereby notify the defendant this plea may not be withdrawn in the event the defendant fails to fully comply with the terms of the sentence I'm about to impose, which is the recommended sentence. So count one, it'd be seven years, 18 months to serve, balance probated. Count two would be 7 years, 18 months to serve, balance probated. Count three would be 7 years, 18 months to serve, balance probated. Count four will be 12 months to serve. Count five will be 12 months to serve. Count six will be 12 months to serve. And count seven will be 12 months to serve. All of this will be concurrent. You are to pay a total of $1,800 in restitution to the victim. And you are to make a minimum payment of $100 a month towards that restitution. No contact with the victim. And you are to enroll upon release. Also, the $100 minimum is upon release as well. You are to enroll in a family violence intervention program, and you must complete that within 12 months upon release. Is there anything else?
I don't think so.
Not
Okay.
from the defense.
You're excused, Mr. Parks.
Yes, I do.
All right, so you want to bring out Ms. Young, right? Let's bring out Ms. Young. Is it Miss or Mr.?
Ms. Young, Your Honor.
Miss Young, okay.
Thank you, Your Honor.
Well, we'll see you. Keep an eye on him. All right, it's 23 SC 186627, Shalaka Young, accompanied by her attorney, Mr. Philip Clark, in the courtroom. And Ms. Clark, is this yours or is this Iqbal?
Yes, Your Honor.
All right. Okay, go ahead, Mr. Clark.
Yes, Your Honor. We're at a position right now where obviously Ms. Young is on the final plea calendar. This is a case I think we really ultimately Ms. Young wants to resolve by plea. I'll let the court know we have not received a plea offer yet. I've communicated with the state. The last point, I think we were here a little over a month ago and requested a plea offer then. I've conveyed essentially what I would propose as a resolution to the state. We're just not in a position that we have anything on the table to resolve it today. So I'll leave it in the court's discretion. I think the state is asking for a little more time to look into it, but I can let Ms. Clark speak on her own behalf. Whether the court wants to bring her back on Thursday or at another point in time. I know Ms. Young is eager to resolve this essentially, and I think there is an avenue for us to do it. You know, and at least negotiate with the state, even if our initial offer isn't accepted by them. But so that's all I can make it as an announcement to the court.
Okay, Ms. Clark.
Your Honor, yes, the state would like some more time to determine an offer. As you recall, at the bond hearing for this defendant, there is an involuntary manslaughter charge that is pending in DeKalb County. So that obviously is going to, you know, take into account, you know, any kind of proposed offer where it kind of put the state on pause as far as an offer that would be extended. Plus, we'll need to communicate with the victim. We are in contact with the victim. I spoke with him. And so Mr. Clark had indicated to me his I guess a possible resolution. So I'll need time to.
Well, I'm looking through my notes and so it's just pending involuntary manslaughter charge at the cab, but we don't have any idea when that's going to be resolved. So how do you plan to how do you plan to resolve this in the future without hanging over you that it can't be resolved today? I guess is my question. Only because this case been out there for a bit.
No, I understand the defendant has been in custody at this point, I think, for about 345 days. I may be.
I believe
Longer than that.
Yeah. Yes.
Yeah, almost two.
Oh, excuse me. That is incorrect. I was looking at the wrong.
She was January
defendant.
last year.
579 days.
Yeah, that
at least
sounds
that.
closer to.
Right. So that being said, Your Honor, I just need more time because, you know, I had been working on, in this particular case, the defendant was, I guess, that there was something about her trying to get her bond reduced. And so that is what I was working for. And I think there was also like some discovery or something that was outstanding that I worked on. So, you know, in lieu of the fact that there is a pending, I'm waiting to hear back from DeKalb County to get more information regarding the involuntary manslaughter charges. Person is deceased, and so certainly in another jurisdiction, so certainly it may take me a little more time to come up with a resolution on that basis. Because prior to me being privy to that, I had a certain offer that I was thinking about offering, but being aware of an involuntary manslaughter charge.
I mean, we knew that it was involuntary manslaughter in July, but so I had that in my notes. So what,
I'm not ready to resolve it today. And the state's not ready to go to trial. So I can try to see if I can work to have something, but I don't want to be rushed into trying to come up with something when I feel like the serious nature of the charges. There's a hijacking charge, there's a robbery charge. That also the defendant has a very extensive criminal history. So
well, but I don't feel like we are rushing on the case. I mean, the defendant's been in jail for a long time now.
right, and the defendant can be given credit for time served, but I just got the case, and so I'm not going to myself to figure out in lieu of all the factors associated with this case and the defendant herself, I'm not gonna rush to make a rash offer without having all of the facts.
I mean, I hear you, but
So I'm speaking for myself. I need more time. Defense attorneys, they come in, they say they need more time. I need more time.
yeah.
It's the only case I've ever asked you for.
Mr. Clark, you feel like there's a chance, a good chance this can get resolved?
I mean, I hope so, based on my conversations. I guess where me and Ms. Young are at and what we discussed, I still think there's a good chance that we're going to be able to resolve this. So, I mean, I guess my thought is, obviously, I understand the state, what they're offering to the court. I just don't want to be in a position where we're here several months from now in the same position. Ms. Young is sitting there. Obviously, she, wants to resolve it. But, she has other things. She wants to be able to start a sentence if that's what needs to happen, or to be transported to the cab if that's what's going to happen. So just in the interest of she has an interest in resolving this expediently, no matter what the outcome ultimately is going to be. So that's my own, if the state needs more time, I would ask no more than, I guess, 30 days.
Well, I'll tell you.
And I'm not asking for a long time. I'm asking for 30 days. But I'm not gonna make a decision.
Well, let me ask you this. We've got what about October 6th? Kathy, what about October 16th? I'm talking about for the trial date. Yeah, but can we stick it on for that? What about October 16th trial?
Is that a final plea day or that?
Final plea would be the 11th.
Okay, that's fine.
All right, let's do that then.
Yes, Your Honor.
All right. Yeah, put it on the final plea of the 11th and the 16th for trial. Anything else? Well, I don't have, give me 1 minute. Let me look. Let's go over this real quick here. So what about Shalaka Young? We just did her. Yeah, Harvey. What's going on with Harvey? Miss Jones is who I was asking it to, but
That's okay. Your Honor, we are still in need of body cam.
That's right.
The state, they're going to get me that. And I may have an issue of competency. I'm just not quite sure.
okay.
If I could see the body cam, that might help me.
All right, well, let's reset this one for 30 days then. Is that all right?
That's great.
No. We'll give him more time than 16th because let's do the one that's after the 16th. What trial date do we have after October 16th? I see we've got that final plea calendar, the 25th.
October 25th? Oh, that's for everybody who's not.
Oh.
Everybody who's in jail, that's
Well, the 23rd, then we have that's our, okay. Well, let's put her, let's put them on there and whatever the next, I don't know if I see the trial date for that. Okay, let's stick it on that then. All right. And then how do we resolve Duval? All right. What about Hardin? Ms. Jones?
Thank you, Your Honor. The state gave me an updated offer that I've discussed with my client. I think we're getting pretty close, Your Honor. I would just request he be placed, it's just kept on the Thursday docket for a calendar call.
All right.
That way I can firm up everything with the state and talk to my client and see if there is a resolution.
You good with that, Ms. Clark?
Yes, Your Honor.
All right, we will do that then. And, oh, Mr. Hardin's 2 cases. What about Malik Murphy? What do we do there? All right, that's right. That's right. 16th trial. And then the 19th, Bridges.
I don't think Your Honor had made a determination on that. I had asked for a reset on this one. This is the fact that she had that other case pending in front of Judge Edwards. And I did note, I would note, this is not the case holding her in confinement. That is actually Judge Edwards' case. So I guess I'm less concerned about continuing this in light of that. And I've discussed it.
Who, Ms. Clark, you've got this one?
Yes, Your Honor. It's fine.
I mean, I've reset it. So the question is, I mean, do we do that the 16th or do we do that for the one in November?
I'd asked almost for November because they just did a plea and arraignment in front of Judge Edwards. And that would give me time to speak with her private attorney on that one.
Assume you don't have any objection to that.
No, sir, I don't.
Okay. The November date is the 13th.
I would think that case would need to be transferred then from Edwards if we've got the lowercase number.
The Edwards case is more recent.
I mean, that'd be the first time that I call a judge asking them to give me the case, but
And certainly if there's a global resolution.
I feel confident there'll be no objection there, but all right, can you reach out to Edward's office, Kathy? On Bridges, apparently there's another, what's that case number?
I don't have that right.
I mean, unless Edwards just want to keep it, then we would have to take it.
Yeah, that's what I'm kidding about. Why don't you reach out to her office and tell her to transfer it over or get it or figure out how to get it transferred? Don't we, I mean, right now it's placed with her, so somebody's got to be.
She can do that, but if she doesn't do it.
Yeah, but we want to put it on there because we're going to go to trial and we want the resolution to include both things. So. I know, but all it's going to do is create another pothole in the road a month from now if we don't do it. So.
Your Honor, do you want those other 2 cases?
I think you have the case number?
Yes, sir.
Kathy, you want to write down?
Okay, she has a case in the jail as well. It's been indicted on, well, it's unindicted. So she has,
I have a 23 number.
okay, 23, okay, you have the 23 SC 188311, okay. And then, unindicted case she has is 23 CP 219544. That's a jail incident. 219544? Yes, 544. Yes, ma'am.
All right, I think that's it, right? All right, we're adjourned. Thank you.
Till tomorrow.
Till tomorrow. That's the way life is around here. Now we've got a 60 defendant RICO case that's coming through the courthouse.
Yes.
Nope. McAfee originally got assigned that too.
Poor guy.
Yeah. I don't think we can do the same time.
I don't know how it's possible because they're discussing, I don't know how it's possible he does anything,
Okay, well.
especially when he's in trial.
Well, what case?
So they're discussing what to do on these multi-defendant RICO cases. For the record, Adams got the,
So, we give you the short answer.
he recused. Adams got the 60 defendant.
Had a court date, she didn't show
Not
up.
my problem, that's all I gotta say.
Well, the only problem is that that we may stop the wheel for some of these judges and we would get, because I mean, if McAfee's in court for literally 4 months straight, I don't know how you'd expect them to.
Because this is what.
Yeah, we have 3 of those big ones going at the same time. That's,
But but Judge Glanville took that voluntarily, so he was already excused from the criminal stuff,
After she got arrested, she filed a motion.
but he'd already had it.
But he's senior, I think, now though.
No, he's the chief judge, Glanville.
Okay.
That I know.
Okay.
A few things.
But I don't think they get.
Pardon me?
I didn't think that the chief judge got dockets.
That's my point, that he took that voluntarily.
Yeah.
Yeah.
He had the time.
She didn't show up, and so the court's like, well, I don't know what happened, just put out the warrant, and we'll figure it out later.
We've got a lot for tomorrow.
And then we had monitored the correspondence with the previous attorney in your office. Something to the effect of, well, she should have changed her address, but she has taken no. However, he wasn't gonna come forward and say this is all my fault, I screwed up and committed malpractice, but that's really what happened. So once I kind of raised it with someone,
So and you are,
I'm his new attorney, she filed an appearance on Friday. Probably had
what did you
Brandon
say?
Thomas.
Okay, Frank Thomas, okay, all right. So I know that,
Yeah, that's fine.
It was from the Davenport, let me see if I can find it.
my name is Christina Clark, I was happy on it.
You got a good memory.
Basically her saying, I guess, memorializing the conversation that she had.
Well, Ms. Davenport basically said, I think it was this, she said something to the fact that I'm not gonna consider anything like either in cases right now, etc.
Okay.
But at that time, I don't think she was aware that the lawyer didn't change his address. It's one thing for the client, you're supposed to change your address, that's their fault, but if your own lawyer didn't do it,
Right.
because she didn't commit a new crime, she just.
But so here's the thing though, like, I guess them referring to the lawyer not getting noticed. So unless he can show, right? I mean, we're like, every notice is provided electronically to the lawyers, and it's on Odyssey.
No, it's his fault, it's not the court's fault, let's be clear, it's not the court's fault, it's his fault. No, when usually, normally, when I get a court date, it doesn't come from Odyssey, I get it in the mail, I get a notice in the mail. When it's on the docket, normally it'll say, like, if somebody puts a change of address, it'll say, on X day, person put the attorney for the change of address, you never put a change of address.
Right, but what does that have to do with, how does that absolve your client from updating her? I mean, regardless of whether or not the attorney got notice or not, we see all the time where defendants that actually follow the bond conditions, and one of the bond conditions on every bond order is that the person must update the clerk's office with their address. I see all the time where defendants will come to court and their attorney does not come to court.
Sometimes that happens.
Right, so the whole thing about us deciding to set aside her, what do you mean,
Her lawyer didn't change the address.
That's negligence on his part for sure.
Yeah.
She
So
has
that's
a real malpractice.
So that's a civil.
No, it is.
Yeah.
But
Christmas spirit.
Christmas, we in September.
Okay.
most of the time, the defendant is in the wrong. This is really.
I mean, she still is in wrong. That's what we're trying to say. It's like understand where you're coming from, but, and I we do know the reality that lawyers call the clients all the time. Like, remember, we got to it tomorrow. Sure, absolutely. But what Ms. Park is saying is that doesn't absolve her from
No, it doesn't.
her
It
duty.
doesn't, but with knowledge though, and in the strictest spirit too. But this is from the court, this is the notice that they sent to her, so we know she didn't get it, shall return.
Okay.
This is going to her, and then I know the lawyer didn't get it.
But see, okay, another thing about this case, this defendant, there is more than one time where this defendant did not appear before. So it's not like it's just one time, okay, the person, she didn't get good notice. There was more than one time that your client did not appear for court when they were supposed to appear for court. So what's your response to that?
I'm just focused on Christmas right now.
You're focused on Christmas.
I am.
You need to be
It's
focused
3
on.
months away.
I mean, what I'm saying is that, so have you, what motion have you filed? Like,
I
what are
didn't
you?
do it
Ms. Kelly?
yet. First, before I do all of that, I like to try to, people are busy. So I
Okay,
didn't want to
Ms. Kelly,
file
so
a
this-
motion, you got to respond to and all that first. But if I have,
So,
the first step is always good.
but see, that's the thing, though. What I'm saying is, I hear what you're saying as far as her prior attorney, but at the same time, it's my, Chief Deputy Davenport declined to, I guess, set aside or agree.
I don't think she knew this though.
What do you mean?
Because when the lawyer reached out to her, he didn't say, hey, this is my fault, I didn't change my address. She didn't know this. All she knew was this, that she never got noticed. She didn't know the lawyer changed his address and never updated with the court. She didn't know, he wouldn't have told on himself like that.
But I know what policy, right? I'm just telling you, regardless of whether or not the attorney got notice or not, policy is that the defendant, we look at the defendant and whether they updated the court, because that's one of the bond conditions that they are obligated to follow.
I appreciate the talking.
Okay.
Thank you for.
I said all that to say that, your client, the Chief Deputy Davenport, based off of the communication she sent to Attorney Lewis, declined to, I guess, set aside anything because it was not just because of the her not receiving notice, but also because the defendant has multiple cases.
I know, I understand though, but, and again, I appreciate you hearing me out. Thank you. Obviously, this wasn't scheduled or nothing.
Right.
But I'm 99.9% sure she didn't have it. That even the lawyer didn't get it.
Okay. Well, I would, let me give you my card, because I would like for us to, I mean, being it's your client, are you gonna be representing her on all the cases?
Well, so. So, I mean, the short answer is, as it is now.
Oh, I'm so sorry. I'm so sorry. Okay. You what now?
As the short answer is, as it is now.
Oh, okay, okay.
Oh,
Okay.
I thought y'all wanted us help.
Okay. As it what now?
As it is now, she's been in jail 30 days, so she can't work. So they can only afford to hire me on one case. If she can get back out, she can get back to work, like she runs a nail salon, hair salon, or something like that. Then they can afford to hire me for both cases. For me, I can't, especially a serious case, I can't file an appearance in both cases and be on the hook for she didn't pay the money. So they only filed into the one with the FCA. I know that's weird stuff, but, you know, I have to charge them my time, so.
But the case with the case that is the one with the FTA is a serious offense too.
It is, no, they paid that one.
Right.
But she didn't pay the other one, so I can't file into the other one yet.
Okay.
But if I can get her out, then she can get back to work. She gets behind these attorneys, she got 30 days to law. She really has a malpractice thing, and aside, that's not the problem, I'm just saying, really the goal was, I'm trying to get her out, she gets out and get back to work, she can do other things, then I can talk about both cases and potential resolution, because honestly, it's gonna be hard to even reach a resolution, because it's like, you're not gonna wanna talk about this one case, you know?
Well, yeah, I mean, I don't.
That's not your problem, that's
yeah,
my problem.
I think so. In lieu of the fact that she has multiple cases and they are, violence against others, right? I just think that it's, I know that you're saying that in your opinion, you view it as malpractice but I was a criminal defense attorney also, for 12 years. And it's not my job to make sure that defendants come to court. The job of the defense attorney is, okay. So I don't agree with that. So because if that were the case, the defense attorney has to, yes, you have to notice the defendant, that they have court, etc. But the reality is, part of a bond condition is the person is obligated to update the clerk of the court whenever they move. That's on the defendant.
I appreciate that.
Yeah, so that's what I'm saying. So I don't think that's gonna, I'm just telling you, whether you talk to me or whether you talk to my supervisor, or Chief Deputy Davenport is my supervisor, I just don't feel that that is a strong argument to say that because the attorney technically did get notice, because it's electronically, he didn't get notice.
No.
Uh-huh.
I'm telling you, brother, when you send a notice for court,
right,
it does not come on.
Okay.
This notice here comes in the mail. It doesn't come on out of.
Okay, well,
I'm telling you, it doesn't. So, like if the court issues an order, it's different. I don't know how exactly their system works, but I know that when there's an order or a motion or something, it's different than this type of notice. It always goes out in the mail. So, just to clarify, I know that doesn't, again, I appreciate you listening to me. Obviously, you have things to do. So, I'm gonna have to take the next step, which is, I guess, filing a motion with all of that, which then y'all gonna have to respond to it and then hearing.
so are you adopting the motion that the prior attorney filed?
No, because I have to throw him under the bus.
Okay.
Which he wasn't gonna throw himself under the bus.
Okay.
But it's clear if you have a different address and you never change your address, the attorney is not just showing up at court. You're supposed to advise what is an arraignment. You're supposed to tell you, okay, we're going to court. They're gonna ask if you have a lawyer. They're gonna tell you what you're formally charged with. He never talked to her. She didn't, because he never got notice. The case was filed in 2020, all of that. 3 years later, then they finally do a court date, but he moved the address. He never told the court. And the defendant moved, and she never told the court. Now she's
been in court. She's been in court. She has been in custody 30 days because she failed to alert the
I
clerk.
got you.
Yeah.
I know the policy and all that, and
Yeah.
I'm just telling you what it is. So I do try to work it out first, and we are gonna have to get ahead of all the motion.
Okay, just make sure you have my email address. Make sure that you copy me on the motion. And that's fine. I mean, Miss Robinson is
So
your
there's like already an October thing.
litigation manager.
Okay.
But I'm not going to agree. The only way you can get a hearing it was less than 10 days is if I agree, and I'm not gonna agree with that. Because there's no notice. You haven't filed your motion. And I need to notify my victim. I'm just telling you. I'm just saying. I need 10 days so that I can properly notice. The victim in previous cases has been here for the hearings that the defendant didn't come to. So I'm gonna have to basically notice the victim because they have a right to be here.
I got you.
So it would be malpractice on my part.
I got you.
Yeah.
But you got the green on, and I'm trying to find the Christmas spirit.
The Christmas spirit?
No, I'm just saying, what can we do?
Being that your client has multiple cases and you said that you can only discuss the case that they've retained you for, I mean, honestly, I just really feel like I'm not gonna, there was some, because your client has committed offenses, if I'm not mistaken, she committed an offense while she was out on bond. So the better question for me is that why did my predecessor not file a motion to revoke her bond?
So she has like a case pending against her right now?
Yes.
You know what it is?
It's an assault case. That's the only thing I can remember.
If I email you, you think you could send it to me? Because obviously that's gonna come up and like I don't have
Right.
that. I only have.
So just so that you will have full information, I'm going to, I'll of course respond to whatever motion you file, but I'm also going to,
Don't say it.
I'm gonna also file a motion
Don't
to
say it.
revoke her bond, so we
man.
can hear both of them on the same day. If you make me work, then I have to work. Then,
But I'm not trying to make you work. I'm trying to get you to consent. Didn't you see that?
oh, I'm not gonna consent.
I'm not trying to make you work.
No, what I'm saying is I'm working, but if you make me do, in my opinion, this is a situation where it's work that's unnecessary, because I feel like if your client had provided, if she had updated her address and she had updated her address with the clerk.
Anyway, there's no attorney.
Right, but if she were here, I had that happen a couple of weeks ago. There was a defendant, his client, his lawyer ended up having a murder trial go 3 weeks instead of the 1 week that he thought. His client was here.
But you know something? This is honest.
Mhm.
I've never, because I used to be a public defender, seen a lot of cases. I've never seen a court put out a warrant when there's an attorney on the case, and I couldn't figure it out. I'm like, why did this happen? Normally, if the court sees there's an attorney, it's like, okay, there's an arraignment. We're not gonna put out a warrant. But because the attorney never got notice, that's why this happened.
Well, I think in this particular case, because I know I was the one that requested the bench warrant, I reminded the judge that the defendant had previously not appeared for the hearing before that. And so on that basis, I said, Your Honor, it's appropriate to go ahead. I said, I tried to be understanding. The defendant didn't show up I know things happen. So the defendant, I'm not going to request a warrant the first time, but the defendant didn't show up the second time. I asked for a bench warrant.
All right. Well, thank you for hearing me. I appreciate it.
Yes, sir. All right. Ms. Robinson, thank you. I will see you tomorrow. I'm sorry. No, I just was saying, thank you. Okay.
I am.
$1,400. I mean,
I know you did.
Whenever she goes, or if she leaves, she has to notify.
You never updated it with the. But the case got started.
That doesn't mean.
There's already a motion of honor for my, that I'm gonna probably suffer.
That's what I